Justice Watchers, before we begin, I want to make this absolutely clear. The following broadcast contains public domain courtroom footage, commentary, and legal analysis. This content is presented under the Fair Use Doctrine as defined by 17 U.S.C. 107 and is protected by multiple Supreme Court rulings, which you see below. This stream is transformative, educational, and journalistic in nature. It includes original commentary, trial breakdowns, legal interpretation, and critical analysis, not raw redistribution. We do not claim ownership over any public domain footage, and all use is strictly within legal bounds. If you're watching this content, you're engaging in a protected, transformative experience, grounded in law, never in speculation. And if anyone has a problem with that, take it up with Campbell, Brady, Miranda, and Irvin. Remember, guys, justice always works better when we watch. So keep watching. See you in the courtroom.
Morning, the state's president, defense counsel, the defendant are present. This one is Justin, but she'll be right back, I know. Oh. Being stealthy.
A lot.
All right. All right, so are we ready to proceed this morning?
Yes.
Okay.
Yes.
Defense ready, the defense ready. My understanding is, do you have anybody else after the next witness?
We do not, Judge.
Okay. And then, so this is another time, Mr. Davis, we had a discussion yesterday where I just let you know there may come a time you will have to decide whether or not you want to testify or not testify. We're not at that point yet, but with the state's representation, I imagine I've had this discussion probably this morning, if necessary. So just make sure you have time this morning, if we're in break or something like that, to discuss that with your attorneys if you need any additional time on that decision, right? All right, then, are we ready to bring in the jury?
Yes.
All right, let's bring them. Please be seated. Welcome back, ladies and gentlemen. Good night's rest. By show of hands, was there anyone on the jury who was not able to follow the court's previous instructions about doing any research, looking up anything, or discuss anything about their services as a juror on the case? Seeing no hands, we're ready to proceed. State and call your next witness.
State would call Detective Bearman.
Sir, if you'll just face the clerk, raise your right hand, she'll swear we're going to get through it.
Do solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth.
You take a seat. You may proceed whenever you're ready.
Good morning.
Good morning.
Now you walked us through July 19th, July 20th, July 21st, July 22nd, July 23rd. What was the next date of your investigation?
That was the day that I actually became involved in the investigation of July 24th.
And how did you get involved?
That was the day I was contacted by my supervisors to take a look at the case.
What was the first thing that you noticed that the defendant did on the 24th?
Going through searches and records, we were able to determine that he had gone to Starbucks and then nail place and Antares Aesthetic Medicine, I believe it was.
And with regards to the nail place, it was called Pretty Nails, is that accurate?
I believe so, yes.
And was one of Barry's credit cards used at Pretty Nails?
Yes.
And with regards to Anna Teresa Cosmetics, was one of Barry's credit cards used there as well?
Yes.
And what card was used there?
That was the American Express card that was used at Cruisers on the 19th.
Your Honor, permission to publish dates 22 as well as 39 Y. And for the record, 39Y, this is the back of the Discover credit card.
Yes.
And then this shows the charge on stage 22 for Pretty Nails for $65.
Yes.
Easy now, sorry. And you said Anna Teresa Cosmetics was also used on one of Barry's credit cards that day?
Correct.
And it was the same credit card as Cruisers,
Yes.
which is the Amex, which was states 3. So the $10 and the $98.50 was the Cruisers,
Yes.
and the $14.54.
That was the Antares.
And we see that on the next page, correct?
Yes.
And you said he also went to Starbucks that day?
Yes. I believe so, yeah.
Were any search warrants done on the 24th?
Several.
Was there a search warrant done on the residence?
Yes.
What, if anything, did you find in the residence?
We seized Chris's wallet, several items, trash. I'd have to go through the whole list, but there was quite a few things taken out.
Okay, let's discuss the trash. Was there anything distinctive about the trash in that particular unit?
It sticks out that goes up with pink trash bags.
Were you able to find pink trash bags in a dumpster for the condo as well?
Yes.
And did you direct someone to pull the pink trash bags from the dumpster?
The narcotics unit was tasked with that.
And you followed the pink trash bags all the way to evidence?
I did not know. Those were in the possession of law enforcement officers the entire time. I actually stayed behind, and once the vehicle, which we had gotten a search warrant for that, once the vehicle was towed, I followed the Jeep to our evidence lot since I was a civilian driver, so it was in police custody the entire time.
And the evidence inside of the pink trash bags, it wasn't open or torn when you first
No.
started digging through them?
No.
And you actually went through those trash bags, correct?
Yes, I did.
And what was found in those trash bags?
There was some Home Depot information in Mr. Schmalbach's name. There was a cardboard paper wrapping for dolly. There was some duct tape on that, some other trash.
So I'm going to direct your attention, your permission to publish 12, 48B, 48C, 15, 28B, 2C, 28A, 39B, B, 39U, 39B, 39W, and 39AA.
And all of this was admitted, correct?
They've all been moved in, all the evidence for the state's moved in.
All right. Publish.
Now, with regards to what you just stated, that you found duct tape. This is the receipt from Walmart, and what date was that for?
That was on July 19th.
And what did Christopher purchase at Walmart?
2 rolls of duct tape, a tarp, and chocolate milk.
And Your Honor, for the record, that states 12. Publishing states 48B. And now I know it can be a little bit difficult to see, but this is the cell phone case that matches the cell phone case that was off of Barry's phone, correct?
Yes.
What is this green and white wrapper?
That is duct tape wrapping.
Is that consistent with the same brand of duct tape that Mr. Davis purchased at Walmart that night?
Yes.
For the record, 48C being published. And on 48C, what if anything do you see in it?
That is the wrapping for the dolly.
And I know it's a little bit difficult to see, but do you know what this is here?
That is silver duct tape.
Is that consistent with the duct tape as well as the dolly that was purchased by the defendant?
Yes.
For the record, 15. Is this the defendant with a dolly?
Yes.
And that's the dolly that was purchased at Lowe's?
Yes.
And this is consistent with the same trash that you disposed of?
Yes.
And in this particular photo, on 15, what is this?
That appears to be an Apple iWatch.
And is that Apple iWatch consistent with an iWatch that was recovered from Barry's residence on the 24th?
Yes.
Now, in that trash, did you happen to find a harness for a cat?
I did not.
Did you happen to find a leash for a cat?
No.
But you did see cats in the residence.
Me personally, no. I never saw a cat.
So no, there was no cat viciously attacking you?
No.
Did you happen to see any harnesses inside the residence when you did your search warrant?
Not that I recall. No.
Did you see any leashes for the cats inside the residence?
Not that I recall.
Did you also do a search warrant on the vehicle?
Yes.
And with regards to the search warrant on the vehicle, did you find anything in the back of said vehicle?
There was several items found.
You're under permission to publish 2B. And this was in the trunk space.
Yes.
And then we have 2C,
Yes.
which is also closer up at the trunk space. Is this consistent with the item that Mr. Davis purchased at Walmart on the 21st of July?
Yes.
And you said that you also were able to look at the outside of the Jeep during the search warrant as well?
Yes.
Is this Mr. Schmalbach's Jeep?
Yes, it is.
And could you describe for the jury the outside area of the Jeep as you saw it on the 24th?
Exactly like that. That's actually outside the house. passenger side, around the doors, up around the wheel wells, on the back tires.
And you did a search warrant of the house, you found his credit card, or sorry, his wallet, excuse me,
Barry's wallet or Chris's wallet?
Christopher's wallet.
Yes.
Publishing 39U. And what is this a photo of?
That's the wallet. That's Chris's wallet.
And with regards to that particular wallet, what is this item here?
That's an identification card from
Publishing,
Alaska.
publishing 39BB. And this is Christopher's identification card,
Yes.
and the date of birth on the card.
6/8 of '88.
And then we have another view of the wallet, which states 39B. Is that accurate?
Yes.
Does that wallet look different than the wallet that Mr. Davis used on July 19th when he purchased the 2 rolls of duct tape, the tarp, and the Fairfield Light chocolate milk?
No, that was the same.
Are the amount of credit cards different?
From the initial night on the 19th, there's more in there from what I could tell. Just looking at it.
And with regards to 39W, this is the content of Mr. Davis' wallet.
Correct.
Are any of those credit cards Mr. Davis's?
No,
Whose credit cards are they?
they're in the name of Bear Schmalbach.
And 39AA and 39B. What is this?
That's the American Express card.
And this American Express card, was that used on the 24th as well?
Yes, that's the one that was used in Therese.
For $1,454?
Yes.
When you went into the condo, was Mr. Davis cooperative with you?
Yes.
And did he tell you what happened the night of the 19th?
That he and Barry had gone out. They had some drinks. He came home, was very drunk, and passed out. And when he woke up at 4 a.m., Barry was gone.
And Mr. Davis said he was very drunk, as in Mr. Davis was?
Yes.
And he passed out and woke up at 4 a.m.?
Yes.
What was the last thing you said to Mr. Davis before he became uncooperative in your investigation?
When he became uncooperative, when we mentioned that he may have been last one seen Barry.
When you did the search warrant on the residence, did you find any items that had a broken screen?
No.
So no watch with a broken screen,
No.
tablet,
No.
cell phone?
No.
Were you able to find Barry's phone?
No.
Now, I believe you told us, I think on day 1, that there was a ping done on Barry's cell phone.
Correct.
Where was the ping's last location?
But I believe it was within 5,000 meters of the residence.
And for us that aren't familiar with 5,000 meters, how would you describe that?
That's a big area. It's probably 2.5, about 3 miles, 2.5, 3 miles.
So, you didn't find it in the residence though?
No.
And you say it's kind of a click, so it doesn't give you an actual location, it just gives you an overview.
Well, it's a ping, yes, so it will give us within that many meters. Whenever we have a missing persons case, that's one of the first things that we do is try to ping the phone.
And did you find anything consistent with an accessory of Barry's phone? Such as a case?
We found a case in the trash can, in the trash.
And that states 48B,
That is correct.
and that's consistent with the same type of phone case that Barry had.
Yes.
Did you also do what is known as a body search warrant on the defendant?
Yes.
What exactly is a body search warrant?
That's where you take DNA, you take photos of the body, consists of mouth swabs, take photos, if there's any injuries, anything like that.
Did you notice anything about Mr. Davis during the search warrant?
Subtle scratches up and down the arms, legs.
And you said you're a high school football coach, correct?
That is correct.
And how long have you been in Southwest Florida?
How long have I been in this? 43 years?
Have you ever been around a cat?
Yes.
Have you ever had injuries consistent on yourself with the marks that you saw on Mr. Davis's body from a cat scratch?
From a cat scratch? No.
Now you said not from a cat scratch and vegetated. Is there something that you've done yourself that would be consistent with the marks that you saw on Mr. Davis's body?
Yes.
And what would that be?
Walking around through brush, stuff outside, scratches on trees.
Just some speculation.
I asked with regards to himself. So with regards to yourself, watching through areas that are more rural and raw.
Yes.
What did Mr. Davis tell you about the scratches on his body?
They were from the cat.
Did he tell you how he got them from the
Yeah,
cat?
he was trying to harness the cat, put leashes on the cat.
Were you able to review a Celebrite report as well after Miss Fordham was able to do an extraction on the defendant's phone?
Yes.
Did you notice him doing any searches for different Airbnbs?
Yes.
Did you see him do a search for an area called Ochapi?
Yes.
What is Ochapi?
Ochapi is a little town. It is probably, if you go down to Naples, if you take 75 and take 75 across the alley, that's why. If you go down 41 and go across that way, Ochapi is a town that way. It's probably about 40 miles south of Naples into the west or to the east. It's on the way going into the Everglades.
So you would characterize it as very rural,
Yes.
and he was looking for an Airbnb there?
Yes.
And did he end up getting an Airbnb there?
No.
Where did he end up getting an Airbnb?
Closer. Montero States.
Now, during your search, or your review, excuse me, of the Celebrite, did you ever notice him search for an area called Devil's Garden Mud Club?
No, I did not.
And are you familiar with Devil Gardens Mud Club?
I am now.
And is it still an area that is open for the public?
No, it is not.
When did it close?
The last review on the website, the last Google review said it was closed in July of 2020.
Now, did you do anything else with regards to the 24th of July?
Just the search warrants, bringing evidence and stuff like that back to the station.
What was the next day that you kind of became really heavily involved with the investigation?
Well, from that point on, I was pretty much involved all the time.
And are you able to take us to what happened on July 29th of 2023?
We did I wouldn't say a grid search, but a search of a very large area in Clewiston.
Can you explain what a search in Clewiston looks like to the jury?
It was expansive. I think we probably had about 50, 60 people out. Vehicles from Henry County, ourselves, Lee County came out and helped. We had drones up. We were looking for a stretch not far from there, Bearman. Looking down a stretch of road. It was pretty extensive.
And what was the area like out there?
Rural, agriculture, lots of, there were some canals, lots of open fields, lots of open areas.
How were you able to decide what areas to search?
At this point, we were just looking for a big stretch of area that was close to the Airbnb that it looked like it could be accessible.
Would you describe Montour as kind of finding something almost as a needle in a haystack?
Put it mildly, yes.
And why would you say putting it mildly?
It's just so open. There's thousands and thousands of acres.
And it's well developed?
No.
Did you end up finding Barry's body?
No.
Did you end up having cadaver dogs help with your investigation?
Yes, we did.
And do you know where the cadaver dogs came from?
Pasco County.
And why did you have them help with the investigation?
We were looking to see if there would be any evidence of remains in the vehicle.
And Your Honor's permission to publish states 2E. Do you recognize this?
Yes, those were the vehicles that were used in the search or in the lineup.
And the cadaver dog, you said, helped with the search of the vehicle.
Correct.
What information did you receive about how to set up for the search?
They just asked for like a lineup. So we used the various vehicle and then 3 other employees from the city, from the police department.
And the 3 other employees from the police department, did you go through their vehicles and clean them before?
No.
Were these well-lived vehicles?
Yes.
What was the age range and the demographics of the 3 other vehicle owners?
I believe they were all females. They all were from our records department. Probably between 30 and 45.
Some of them have children.
Yes.
Were the cars in pristine condition on the inside?
I didn't go through them. I mean, they looked like they were active in-use cars someone every day.
Did you tell Pasco County which car is the one that you wanted them to search?
No.
So what did you have to do once you lined these vehicles up?
We lined them up and then we stepped away and then the dogs did their thing.
And how did you move Barry's vehicle around in the parking lot?
I did not. When the evidence text did that, she suited up in the anti-contamination suits, the white suits that you normally see with boots and gloves, and she moved it.
The other drivers for the other vehicles, were they suited up the same when they moved their cars?
No, they moved their cars.
So you witnessed Miss Buckner going into the vehicle in a contaminated fashion, not to leave any sort of hair, body.
Yeah, and I saw her get out of the vehicle. I didn't actually see her get in the vehicle. If you look in that back building on the right corner, that's the garage where it was parked at. So I saw her when she got out.
Was the Jeep kept in a way not to be contaminated by other vehicles?
It was locked up in its room by itself until we released it.
Did you actually witness the dogs run?
Yes.
And how did they run that day?
I believe one was off leash and then they put it on leash. I don't remember the second was off or not.
Were they running both dogs at the same time?
No.
Were they watching each other as they were running the dogs?
No.
And you never told them, or anyone told them, which vehicles were
No.
Since Barry went missing on July 19th, 2023, were you able to look to see if he flew out of RSW at all?
He did not.
Have you yourself flown before?
Yes.
And what items do you need to be able to get into an airplane?
One is ID and 2 is ticket
How do you usually purchase a ticket?
with the credit card.
Did you also have a passport?
Yes.
Did you find Barry's driver's license
Yes, on the 28th.
in the wallet?
Yes.
And did you find Barry's passport
I believe it was in the safe when we got into the safe.
on the 24th?
I don't know if it was the 24th when we actually got into Barry's safe. I think it was a little bit later than that.
Are you aware if he ever applied for a new driver's license?
Not that I'm aware of, no.
Are you aware if he ever applied for a new passport?
Not that I'm aware of, no.
Has there been any other activity on Barry's accounts other than what the defendant has used his credit cards for since the evening of July 19th, 2023?
Other than them not being paid, there's been no activity at all. No payments, no nothing.
It's been mentioned by witnesses that Barry was flying to Chicago in August. Were you able to verify when he was supposed to be flying to Chicago?
I believe it was, I want to say it was August 2nd. And I actually called out to the airport that day. And I had the police department out there make contact with the airline to see if he had checked in, if anybody had flown, and they said no. And they actually did there's LPRs out at the airport, and actually did LPRs for vehicles and stuff that were assigned to either vehicle, and there was no activity at all.
When was the last text message that Barry sent out?
The last one from his phone was around, I'd have to look again at the records, I would say it was 7 p.m., something like that. It might have been later.
Would you say that the last activity on his phone was at about 9:30, whether it be text message, phone
Yes.
calls,
Yes.
and he never called out after that time?
No.
He received multiple calls in,
Yes.
but none of them were answered other than a PNC call.
Correct.
Is the last time anyone sees Barry on any sort of camera the one at Greco's Jewelers?
That's what I've been able, in the course of my investigation, that's the last time I was able to obtain that information.
And the passport of Barry's, was that near or in the backpack in the office area of the condo?
I believe so.
And to your knowledge and through your investigation, who was the last person to be with Barry?
Well, would have been the last person on video with him, so Chris.
No further questions.
Indicated the search of the condo.
Yes.
Did you recover firearms?
Yes.
How many firearms were in there?
I'd have to look at the inventory return.
There's
Couple
both-
handguns, I think, couple long guns,
Okay. There were various firearms?
as far as we were able to check, yes.
Okay. And in the course of your investigation, you ended up actually talking with a person named Tyler Gamble?
Yes.
Okay. You took a statement from him?
Yes, over the phone.
Okay. And it indicated to you that it wasn't uncommon for Chris to use his Airbnb account because Chris's account got closed?
Yes, he said that there was an issue with Chris's account for a place that they stayed in Vegas that got messed up. But that, after that point, he used it.
All right, and then you indicated the search warrant was done on the Jeep, and you actually stayed back and then followed the Jeep to, I guess, the evidence?
Yes. Once it was hooked up on a tow truck, I followed the tow truck to the station.
All right, so, if you recall, how do they tow it? Do they put it like on dollies? or
They
do
put it on a flatbed.
They just, do they pull it up,
Yes, sir.
like a wire and cable?
Yes, sir.
They pull it from the rear,
No, I believe it was front.
in the front?
Oh, well, actually, they backed it out from the front, and then,
Okay, and then,
because it was pulled in that way, we had to pull it out from the back.
this is a tow truck company, and you just call whoever's on the road?
We have, for cases like that, we have one tow company that we use. I don't remember the name of it off the top, that's not a rotational tow, that is a one for search warrants and stuff like that, and stuff like that, it's one company.
All right, and you said you never saw cats in the condo?
I did not know.
Do you know who removed them prior to you getting there?
I don't know if they were removed or not, I did not personally see them, I don't know if they were hiding under beds or anything like that, I just did not see them.
Okay. All right, and then there was talk about the charge on the card at Ann and Teresa.
Yes,
Did you learn that Mr. Davis had previously been there for a consult at one time?
I'd have to go back and double check that.
Okay, I was gonna ask you if you had any idea if that card was already on file from when he did the consult. Would you know that?
Not without looking at my records, no.
All right, and when you said the last ping of Barry's phone, the location was within 5,000 meters
I believe that was correct, yes.
of the condo?
Yes,
And would that include the area where the wallet was found in the drain?
yes.
And then the passport, I was confused about the location of that. Was that in the safe or was it near like a backpack and some medicine?
Actually, I misspoke, it was not in the safe. There was a lot of personal identification stuff. The passport was in the house.
Okay. Also, in the search warrant of the condo, did you come across syringes?
Yes,
Okay, and then some of them were used syringes.
Yes,
And that was, I guess, investigation led that it was medication Barry apparently was taken.
yes.
Thank you.
No follow-up, Your Honor. We asked to retain, but
You may
we
step
not.
down, but you're not released.
At this time, Your Honor, the state rests.
Okay. Ladies and gentlemen, I'm gonna send you back to the jury room for a few minutes. We'll call you back out in a minute. All right.
So we'll address it one at a time, Your Honor. First off with the, Your Honor, so for count one, second-degree murder, we would be arguing at this time that the state hasn't presented proof sufficient to establish what is required for this court. Specifically, we're arguing that they're relying on improper inference stacking. So the first case we're citing to is Gustine v. State. It's a Supreme Court of Florida case from 1923. The citation is 97 Southern 207, 1923. It's the case that establishes essentially inference stacking. It's an attempted larceny case, but essentially, the facts are that the defendant was charged with attempted larceny. The defendant did not start the car, though he manipulated wires, and the court ultimately overturned that conviction because if the facts and proof are equally consistent with some other rational conclusion than that of guilt, the evidence is insufficient. And if the evidence leaves it indifferent, which of several hypotheses is true, or merely establishes some finite probability in favor of one hypothesis rather than another, such evidence cannot amount to proof, however great the probability may be. And so, essentially, this is an old case, but this case was expressly upheld still, even after the change in the JOA arguments by Garcia v. State, and that's going to be the case 373 Southern 3rd 1213. That's the Florida 3rd District Court of Appeal from 2023, and they specifically do a whole analysis on whether this is still good law, and they explicitly find that Gustine's legal principles prohibiting a conviction based on the pyramiding of inferences remains valid even after the Bush opinion that eliminated the special standard for JOAs. I would direct your attention to page 27. That's essentially kind of where the analysis holds that, and also the analysis on Gustine still being good law. And that's based upon them finding that the sister courts are still upholding it, as well as the use of the axiom of sub silentio. Basically, Florida Supreme Court does not overrule itself silently, they do it expressly. And it's actually important to note that in Garcia v. State, the 3rd District Court of Appeal certified this question, like, is Gustine still good law? They certified it as a matter of great public importance to the Supreme Court, but the Supreme Court ultimately denied review of that case, and it was established and stayed that same way. So, they go on to basically say circumstantial evidence is proof of certain facts, and circumstances from which the prior fact may infer the ultimate facts in dispute existed or did not exist. But I think our concern here is that there's not enough evidence in our case to elevate the disappearance date to an established fact beyond reasonable doubt. So there is this sort of subset of case law in the inference stacking, which basically implies that certain facts, if there's not another reasonable hypothesis, can become established facts. But the issue really for this case is that this is known as what's called the Volcker exception. Essentially that an inference may be admissible into evidence, and it can be the cornerstone of other additional inference stacking if it's to that degree where it's that fact has been established to a reasonable doubt. Interesting to note, though, is they do a whole analysis on this exception. It's only been adopted by the first and second DCAs here in the state of Florida, specifically for criminal cases, and the third DC actually decided not to even adopt it. And it's mostly done in civil cases, but it has been slightly adopted. So, the standard, this Volcker exception, is when no contrary reasonable inference may be indulged, such an inference is elevated for the purpose of further inference. We would be arguing that no evidence actually exists to elevate any of the facts established here by the state so that this inference stacking can occur. Garcia is a very on-point case, very similar, alleged homicide, no body was found, similar facts. There's these allegations of fraud in this case, but that's about a check fraud, but still very much on point. And they really start focusing on the fact that there's this date after which nobody hears from the alleged victim within Garcia's case. And that's very similar here. They note in Garcia, which is these facts are similar, that, basically no body's ever recovered, there's no exact time of death, no crime scene to establish the location, time, cause, or manner of death, no eyewitnesses to the death, no confession. Similar to our cases, there was some evidence introduced through statements by Mr. Davis to the police that there was some sort of Italian dinner plans being made. There were some text messages about that, as well as text messages which show that there was maybe communication after the time frame the state is attempting to show that Mr. Schmalbach disappeared or something occurred to him. We've heard evidence that the text messages were slightly different, space, period, space, but even within those text messages submitted into evidence by the state from June of 2023, a month before the alleged disappearance, you see that there's times where Mr. Schmalbach doesn't use that space, period, space, even though, there's this whole line of questioning and evidence suggesting that he's very consistent with his punctuation, even though we see the inconsistencies within the evidence admitted into evidence. And again, at this time, the 6th DCA hasn't adopted this. This is only the first and second, and some jurisdictions haven't done this. Specifically, the third hasn't adopted it. So we would argue that even if the court thought that this rose to that level of beyond a reasonable doubt at the time of the disappearance, this court would have to adopt this standard by one of the other courts. Otherwise, it would just be another inference upon which they would have to stack other inferences. So, going further into it, the court also found in Garcia that the jury could not reach the conclusion with inference stacking that the death of the victim was caused by criminal acts. The defendant in Garcia could be because of the pyramiding off of the foundation of the victim's death on a particular date at a particular time. An impermissible pyramiding of inferences occurs where at least two inferences in regard to the existence of a criminal act must be drawn from the evidence and then stacked to prove the crime charged. And in that scenario, it said that the evidence lacks the conclusive nature to support a conviction. Basically the same language that they're pulling from Gustine after they found that it's still good law, even after that change in 2021. Again, they also note that there's a difference between inference stacking and putting the pieces of a puzzle together, suggesting that, in some cases, defense counsel might argue that, we're arguing it's inference, but in this case, the state was trying to argue that they're putting the pieces of a puzzle together. We would argue that the state hasn't put the pieces of a puzzle together. Essentially, they bought a puzzle from Goodwill. It doesn't come with all the pieces, Judge. In Garcia, the DCA found that the puzzle the state argued for was missing significant pieces of evidence that required the jury to resort to sheer conjecture and speculation to fill in major gaps. Again, they cite to certain missing items: no established time of death, no crime scene to establish location, cause, or manner, no weapon or eyewitnesses, no confession. Despite missing evidence, the state wanted the jury to fill in the missing evidence from the chronological inferences from the circumstantial evidence which was being presented to the court and the jury, which is essentially what we've seen here in Mr. Davis's case. Ultimately, several of the facts are very similar to what we've seen here. And actually, they even had a little bit more evidence in this Garcia case than what's been presented to the court. In that case, there was this whole thing about Garcia going on and trying to show that the deceased was still alive, driving the car, making ATM withdrawals. We don't really have some of that evidence similar to this. There is something interesting in the Garcia case, which I find very distinguishing, is that they did luminol testing in the vehicle, and they found a hammer outlined by luminol in the interior of the car. And then they speculated that they used the car to discard of the hammer, also a purse that was outlined by the luminol, and possibly a body. We didn't really see that. They just had some generic, like, oh, there's some stains, nothing like the luminol, which would give maybe a presumptive positive that there's blood or something evidence there. They also go on to elicit that, the car was still present. It made it seem like he was still present, things like that, none of which is here in this case. They talk about in this case that the cell phone continued to have activity for several days after the incident, but ultimately, there's been some suggestion of that, but no actual proofs, just another inference. So ultimately, they overturned that conviction for the second-degree murder and reversed and remanded for the JOA to be entered because it was just a lot of inference stacking without that foundational base that was necessary. I've also cited here Ferris v. State, which cites to, so Ferris v. State is 2025 Florida Appellate Lexus 2544, Florida 4th DCA 2025. That cites to O'Flaherty Lewis v. State 237 3rd 15, Florida 4th DCA 2017. And it does have the notation cleaned up, but it's the 4th DCA cleaning it up, so I'll let it be what that is. But they do make a mention, direct evidence of intent is rare, and intent is usually proven through inference. Thus, they're going to have to establish, besides through an inference, that there is some sort of depraved mind, mens rea, that's required for a second degree, and we don't believe that's evident here unless they do these impermissible inference stackings. Especially with the idea that from the 4th DCA that intent is usually proven through inference. And again, the crime of second-degree murder, however, requires the more serious mens rea, which I was mentioning about the unlawful killing of a human being when perpetrated by an act imminently dangerous to another and evincing a depraved mind regardless of human life, although without any premeditated design to affect the death of any particular individual. And a lot of the cases on that point, it's usually like a stabbing. Well, the act of stabbing itself is of the depraved mind. Oh, there's a shooting, the gun was very close to the head. That would show that depraved mind. We don't have anything of that here, Your Honor, so we would argue that it's all impermissible inference stacking. We'd also point out to Light v. State, essentially proving that the defendant's intent or state of mind, which is critical for second-degree murder, can be particularly challenging without a body or clear evidence of the circumstances of the case, of the death. And in that case, the court noted that second-degree murder typically involves ill will, hatred, spite, or evil intent, which can be shown circumstantially, but again, we would be arguing that it's all related to the inference stacking. Now, going on to the count 2, tampering. The tampering statute outlines It is unlawful for any person knowing that a criminal trial, proceeding, or investigation by a duly constituted prosecuting authority, law enforcement agency, grand jury, or legislative committee of the state is pending or is about to be instituted. That's 918.13 Florida statute. Specifically, A states alter, destroy, conceal, or remove any record, document, or other item with a purpose to impair its verity or availability in such proceeding or investigation. I'll actually draw the court's attention to 918.13 subsection 1A, where it specifically states alter, destroy, conceal, or remove any record, document, or other item. It's very specific language. We would actually be objecting to count 2 in their jury instructions for the state. I noticed it this morning, just these arguments, we'll go to that later when we have our charging conference, but they actually included a broadening of that language to include remove any record, document, or thing. An item and a thing are very different, and we would be arguing that they're essentially broadening it. We would be just relying on basic statutory interpretation. Basic rules of that law should be given its plain meaning. If it says something very particular, it means that very particular thing. In criminal law, we have the expression expressio unius est exclusio alteris, the rule that there's a term of limitation. Anything not included must be excluded. So when they're saying a thing, we would be arguing that an item and a thing are different, and we would even argue that an item is not a cadaver or body, if that's what they're suggesting was actually tampered with in this case. One of the other statutory interpretations is that statutes should be interpreted so as to be harmonious with other laws. And there are other Florida laws dealing with the improper disposal of a corpse or a cadaver. That's 406.11, 406.12. For instance, that gives the requirements for disposition of human remains, specifically that when any person dies in the state of criminal violence, it's to be reported to the medical examiner. And then 406.12, duty to report and prohibited acts. So we would be arguing that this statute is not in harmony with the other statutes, so we would be asking for a judgment of acquittal on that as well. And then lastly, counts 3 through 10, criminal use of personal identification of the deceased. We're going to argue essentially inference stacking as well. There's been no evidence introduced that Mr. Davis did not have the permission of Mr. Schmalbach to use the credit cards that he was alleged to be using, or has been using, sorry. Specifically the statute, under which he's been charged, 8A. So 817.5688A Florida statutes, any person who willfully and fraudulently uses or possesses with intent to fraudulently use personal identification information concerning a deceased individual or dissolved business entity commits the offense of fraudulent use or possession with intent to use personal identification information of a deceased individual. Our focus is really on the who willfully and fraudulently uses. Willfully means intentionally, knowingly, and purposely, while fraudulently means purposely or intentionally suppressing the truth or perpetuating a deception. Again, even the state's own evidence submitted into trial, such as the Discover records, they point that there was all these payments after 7/19, they were paid by the car, they were paid by the Apple Watch, but we also see those exact same payments before 7/19, whenever Mr. Schmalbach was still answering calls and things like that before his reported disappearance. And that's what I'm going to draw your attention to Tinker v. State, and they just go into an analysis on willfully and fraudulently, and specifically as to a deceased individual. That one's more about property fraud, things like that, but it's directly on point with this because it is an analysis of this particular statute. We also heard from, the witness from the Annalise Theresa anesthetic medicine place. That's very common. It's not uncommon for spouses and partners to use significant others' payment methods. And we heard from, at least 1 or 2 witnesses, specifically at least Ms. Gleason, someone who actually knew about the relationship between Mr. Davis and Mr. Schmalbach. That this was a relationship unlike any that she had seen Barry have in the past. So we would be arguing that essentially that kind of shows this continued permission, and there would also have to be the inference that he was using it fraudulently, but also the inference that Maybe Mr. Davis even knew that there was Mr. Schmalbach became deceased, even though there hasn't been really a showing of direct evidence. Again, it would just be an inference. So with all of that, we would just be arguing for a judgment of acquittal on all the charges at this time, Your Honor.
State response?
Absolutely.
If I may approach, Judge, I'm going to hand the court what's previously, or what's going to be identified as Crane versus State, 894 Southern 2nd, 59, Supreme Court of Florida decision out of 2004. Myers versus State, which is a Supreme Court decision out of 1997, cited at 704 Southern 2nd, 1368. And Sochor versus State, which is cited at 619 Southern 2nd, 285. 1993. Court will note those are a little bit more recent than the 1923 case the defense counsel cited. Judge, despite the inability of authorities to find the victim's body in this particular case, there is competent, substantial evidence to establish that Mr. Schmalbach is in fact dead and that Christopher Davis is in fact the one who killed him. Corpus delicti in this particular case, Judge, can be proven circumstantially, even without evidence of the discovery of the victim's body. We've established the corpus delicti based evidence of a 58-year-old victim's character, traits, habits, and relationships, which negates theories of suicide, natural death, accidental death, justifiable or excusable homicide, or continuing life in absentia. Based upon the totality of the circumstance, Judge, this constitutes substantial competent evidence from which the jury could reasonably have excluded all inferences other than the fact that Mr. Schmalbach is dead and that Christopher Davis killed him. Defense counsel wants to go ahead and allege that we have impermissible inferences and stacking. But in this particular case, Judge, the case law specifically cited by the state with regards to Myers and Crane and Sochor, specifically, the state must establish the fact of death in this particular case and that the criminal agency of another as the cause thereof and the identity of the deceased person. And that is Crane versus State, 894, Southern 2nd, 59, 2004, citing Myers versus State at 704, Southern 2nd, 1368, which is that Florida Supreme Court 1997 decision. Now, regarding the second element of criminal agency of another, proof need not even show that the defendant is the one who committed the crime. What we need to establish, Judge, is the fact that the victim was in fact, what we have in fact established is that the victim was reported missing on the 23rd of July, 2023 by Mr. Christopher Davis at the behest of his friend, Mr. Miguel Blanco, after not having seen or heard from him since he left Cruisers that night, which would have been on the 19th of July, 2023. Family, friends, neighbors, and colleagues stated that it was not unusual for him not to contact them. They stated that it was unusual for him not to call, text, or email, even if he planned to be gone or when he was to return. Most of Mr. Schmalbach's belongings, including his identifications, were still at his residence. The victim's family and friends also reported him missing on or about that same time after not hearing from him. Mr. Schmalbach has not been seen or heard from by any of his friends, his family, acquaintances, and or co-workers since his disappearance. The facts surrounding his disappearance indicate that such an absence without contacting family or friends are out of character for him, and the fact that his belongings, his medications, his identifications, his valuables, as well as his vehicle were left at the residence indicates that the absence was not of his own volition. And in addition, Judge, the continued absence of Mr. Schmalbach, along with these facts, indicate that a death resulted from the criminal agency of another. In addition to Mr. Schmalbach's body never having been found, we offered the following circumstantial evidence. We offered that there was in fact an argument. There was a struggle in the condo. There was a removal. There was relationships with his family, friends, neighbors, and colleagues that have not been acknowledged by anyone and responded to by anyone. There was no expression of any desire or intent to leave any of his family, friends, or neighbors by Mr. Schmalbach. He was looking, in fact, forward to work and spending time with his friends and family up in Chicago. He always let someone know when he was going, when he was coming back. His wallet was left behind, containing his identification, his credit cards. And not only was that only seen on the 22nd, Judge, but later it was disposed of and recovered on the 28th. His watch was also left behind. You heard the fact that he wore that on a regular basis. He left his passport. He left his Jeep, which was his business. His safe and his contents were also left behind. None of his things were missing from his room. His phone records of his last text and call were July 19th, 2023. Cadaver dogs alerted to the back of Mr. Schmalbach's Jeep. The lengths of which Mr. Davis undertook to cover up his deeds with the texts, the credit card usage, and the changing of the door locks, we have introduced sufficient circumstantial evidence to prove that, in fact, the corpus delicti of a homicide has, in fact, been established, Judge. The standard of review is asking simply whether the state presented competent, substantial evidence to support the verdict, Judge. Should be used in all cases when the sufficiency of the evidence is analyzed, even when the conviction is wholly based upon circumstantial evidence. And if I may approach, Judge, I'd like to provide a case to the court. It's cited at Bush v. State, 295, Southern 3rd, 179, 2020. Once again, another Supreme Court decision out of the state of Florida. In that case, Judge, the court cited that the court must view the evidence in light most favorable to the state. Maintaining this perspective, asked whether a rational trier of fact could have found the existence of elements of the crime beyond a reasonable doubt, whether there is substantial competent evidence to support the verdict and the judgment, substantial evidence as such, relevant evidence as a reasonable mind would accept as adequate to support a conclusion, and instructing the evidence is competent if it is sufficiently relevant and material. This standard should now be used in all cases where the sufficiency of the evidence is analyzed. Judge, based upon all of the facts and circumstances the state has provided to this specific court, this evidence that we have laid out over the past 3 days alone is sufficient to sustain a conviction for second-degree murder. As it relates to the Sochor case, Judge, I would specifically point out in that particular case, the court found that evidence that a victim was last seen screaming for help with the defendant on top of her, and that it was uncharacteristic for her not to come home, and that none of her belongings were missing from her apartment was sufficient to establish corpus delicti for a murder, although the victim's body was never found. And they even went so far as to say, in proving that the corpus was sufficient, the circumstantial evidence is sufficient, and proof beyond a reasonable doubt wasn't even necessary in that particular case. In that case, Judge, the facts were such that the victim disappeared New Year's Eve, not been seen from or heard from that night. It was uncharacteristic for her not to come home. She had a good relationship with her family and her boyfriend and kept in touch. None of her belongings were missing from her apartment. There was information regarding the victim that she was screaming for help with his brother on top of her. They found that was sufficient evidence that the victim was in fact dead and that her death was due to the criminal agency of another. And Sochor piggybacks more or less, Judge, off of the Crane decision. In the Crane decision, Judge, the evidence there was sufficient to establish corpus for a murder. And in that particular case, Judge, they found that in addition to an abrupt and permanent disappearance of a young child, supporting the inference that the person was dead, there was evidence that she was last seen alive in the presence of the defendant, that her blood was found on his boxer shorts, and that scratch marks were consistent with fingernails that were found on his body. And although independently not determined, they noted that the defendant oddly targeted bleaching of his bathroom in the middle of the night, along with his unusual behavior the next morning, supporting conclusion that the defendant's actions with the girl the previous evening was unlawful and resulted in her death. They concluded that the totality of the circumstances constitutes substantial competent evidence from which the jury could reasonably have excluded all inferences other than the fact that she was dead and the fact that the defendant killed her. Based upon all that, Judge, we've established beyond the exclusion of every reasonable doubt, even at the bare minimum standard at first JOA, that all inferences are drawn in favor of this, should be drawn in favor of the state. We've established second-degree murder. Now, with regards to tampering with evidence, Judge, we've clearly established that. We're not saying that he got rid of the body and that was the tampering of evidence. What we're suggesting, Judge, is the fact that he got rid of the wallet, and not only that, but he also got rid of the pickaxe and the shovel. Those were items and he knew that there was going to be a investigation, that there was going to be a prosecution, so he got rid of those particular items. Now, as it relates to the fraudulent use of personal identification information, you have an abundance of information with regards to the use, the videos, and all of the records, the bank records, the photographs, the receipts of all these various places in which Mr. Davis decided to help himself to Mr. Schmalbach's credit cards, his personal identification information, even the phone calls where he tries to feign the fact that he's in fact Mr. Schmalbach when he was in fact not Mr. Schmalbach. Judge, all that occurred after the fact that Mr. Schmalbach went missing on the 19th of July 2023. And he wants to say he had permission. We suggest that he did not have permission, especially after he killed him and got rid of his body. And based upon that, Judge, the state respectfully requesting the court to deny the motion for judgment of acquittal at this time.
Mr. Reddick, your vote?
Yes, Your Honor, just briefly, if I may. The state cites to Socher v. State, Myers v. State, Crane v. State, all older cases. You know, they point out my case is 1927, but it was expressly upheld by 2023, the most recent case. We would also point out that Crane v. State deals with corpus delicti. Not really relevant, we would argue here, based upon the inference. You know, they specifically, in the case notes here, Myers talk about corpus delicti in a homicide case, state must establish fact of death, criminal agency of another, an identity of the deceased person, and more importantly, that, you know, typically corpus delicti deals with proving this element before a defendant's own confession is introduced into the record. We don't even have that, Judge. Which actually goes back to the arguments we made about Garcia. There's a general lacking of this solid evidence, and it's all inferences that the jury would have to make and impermissibly stack to get to where they could, you know, make a determination here, Your Honor. You know, we talk about Socher v. State here. That's the case cited to evidence that victim was last seen screaming for help. The defendant on top of her. We don't have any of that. That it was uncharacteristic for her not to come home, and that none of her belongings were missing. If the court, you know, looks at Garcia, I mean, they do even find that, you know, there is enough circumstantial evidence in that case. We'll admit that in Garcia, that essentially, you know, a lack of communication, you know, and a showing of constant communication before could be enough to establish that inference. But what our concern is that in that case, they had to essentially, the court had to show that that first inference of the date of the death of the victim in Garcia was in fact the foundation upon which other inferences could be built off of, and as a result, only the first and second districts have done that. 6th district has not, and other districts have not, the 4th and 3rd included. So we would be arguing that this court would have to find that that fact was established beyond a reasonable doubt to allow the inference stacking of everything else. You know, they talk about, oh, there are scratches in this case for Mr. Davis. That's been, you know, explained by, there was suggestions of cat scratching. They want to infer, again, that it was from these bramble bushes or something out in the pokies of Hendry County, essentially. Glades County, I believe. But, you know, I mean, you know, we talk about cat scratches, I mean, but they're so anonymous, synonymous with cats. I mean, you know, talk about oldies and, you know, as a goodie, you got Ted Nugent's cat scratch fever. Everybody knows about cat scratches. It's a thing. So again, there's these reasonable inferences that can be inferred, and nothing's been established beyond a reasonable doubt to start stacking these inferences. So we would just argue for the judgment of acquittal at this time, Your Honor.
Case law, and I reviewed these cases actually prior to your motion, and I reviewed the state's cases as well as the defense cases. I've also reviewed all applicable statutes and considered the testimony and evidence presented thus far in the trial or to deny the motion for judgment of acquittal. Now, Mr. Davis, this is where we would have a conversation if necessary, regarding whether you want to testify or not testify. My understanding from your juries is, other than yourself, that you do not have any other witnesses to call. So, have you made a decision? Have you had an opportunity to talk to your attorneys about whether you want to testify or not testify? Yeah. Okay. Have you made a decision in that regard? Yeah. And what is your decision? Okay. Do you need any additional time to talk to your attorneys? Very well. So we bring the jury back in, and then if it's rest, is that correct?
Yes.
Okay. And then we would place the jury out, have a charge conference, and then come back with closing arguments. Do you have any kind of estimation in terms of how long the closing arguments might be? I'm not trying to pin you down completely. I understand it's had several days of evidence and testimony. And the only reason I'm asking you this is if we do the charge conference and then start, bring the jury in and start the closing arguments, and then have a lunch break and do the closing arguments, that's probably not ideal. So what I might consider is doing the charge conference, we'll go over that, let the jury be excused maybe to an early lunch, and then come back, and then we can start closing arguments and go straight through that. That's just my idea, but I'm open to other ideas.
We would argue probably for an hour and a half for both the state's first close and the public close.
Okay.
Defense would be that or less.
Okay. So, what do you all think? It's 10:15 now. I can bring the jury back in, let the defense rest, then let them go for an hour or so, and maybe get an early lunch, and come back. We can start before noon. I'm not saying we have to wait till afternoon, but what are your thoughts?
Yeah, Judge, I think the state's in line with the court, and it's David would echo the court sentiments with regards to engaging in the charge conference. Obviously, there's some issues that we need to address as it relates to the various jury instructions. I think it might be prudent to let them go at this point in time. Perhaps,
And I can let you all have some lunch too. I'm not trying to deny you all this opportunity.
Yeah, I don't know about that, but other than that, we are ready to go forward, Judge. But yeah, we echo the sentiments and concern of the court.
Ms. Mitchell, Mr. Ray?
Sounds fine.
Okay, so let's say we let them out, come back at objections or anything to
Just the one issue that you kind of mentioned.
the wording? Is that gonna be?
That's not going to be an issue, Judge. We'll address that.
So then maybe have them come back at 11:30 would be sufficient.
Yes, Judge.
That gives us time to have a charge conference and for you all to step out and get something yourselves or prepare whatever you need to do.
Perfect, thank you.
Is that all right with defense?
Sure.
All right, so let's bring them in. You can rest and I'll tell the jury here's there's still 11:30.
George Enterings.
All right, please be seated. Both the state and defense have rested their case. What I'm going to do is I'm going to let you go early for an early lunch, and then come back here at 11:30, and then we can proceed at that time with closing arguments. So it's 10:15 now. You have a little extra time, and just be back here at 11:30. Please remember the court's instructions. Don't do any research, look up anything, or discuss anything about your services as juror in the case. Don't watch any local news or read a newspaper or anything at this time. And we'll see you back here at 11:30. Just leave your notepads here.
All right.
All right. Let the record reflect the jury's exited the courtroom. Any other motions this time now that?
We would just renew our judgment of acquittal arguments with all the same before, Your Honor.
All right, very well. I do find that, again, that the state has met its burden of providing competent, substantial evidence sufficient for it to deny the motion for judgment of guilt. Everybody's got a copy of the jury instructions. Are you all ready to go through those?
Yes, sir. All right, so I know all the attorneys have been in trial some fingerprints and what I'll do is I'll read the heading. And you just would look to the defense to say no objection. I presume the state doesn't have an objection unless they see something, but they promulgated the proposed jury instructions, so I presume they're in agreement. So that's why I just asked the defense to say no objection. Okay. Of course, if you do, then you can say that. So, introduction to final instructions.
No,
Statement of charges.
no objection.
Introduction to homicide.
No objection.
Count one, second degree murder.
No objection.
Whether or lesser included crimes or attempts.
No objection.
Count one, lesser included manslaughter.
No objection.
Count two, tampering with physical evidence.
That's the one where in prong 2, you notice it says,
It says thing.
yeah.
And you're saying the standard instruction says item?
Now, this, the information says thing 2, but the statute and the jury instruction indicate or other item.
You said the statute and the standard jury instructions say item?
Or other item.
Any objection to changing that?
Not at all, Judge.
All right, so we'll change that. So what's the wording you want? Or other item?
Alter, destroy, conceal, or remove any record, document, or other item.
Okay.
With the purpose of there.
So just or other item instead of thing.
Yeah.
Okay. make that change. Count 3, the fraudulent use or possession with intent to fraudulently use personal identification information concerning a deceased individual, Prince Target.
No objection.
Count 4, fraudulent use or possession with intent to fraudulently use personal identification information concerning a deceased individual, Publix.
No objection.
Count 5, fraudulent use or possession with intent to fraudulently use personal identification information concerning a deceased individual, PNC Bank.
No objection.
Count 4, fraudulent use or possession with intent to fraudulently use personal identification information concerning a deceased individual, Starbucks.
No objection.
Count 7, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual at Walmart.
No objection.
Count 8, fraudulent use or possession with intent to fraudulently use personal identification information concerning a deceased individual, Seacoast Bank.
No objection.
Count 9, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Home Depot.
No objection.
Count 10, fraudulent use or possession with intent to fraudulently use personal identification information concerning a deceased individual, Ann Therese Aesthetic Medicine.
No objection.
Plead not guilty, reasonable doubt, and burden of proof.
No objection.
Weighing the evidence. This is where we have the itemized things that sometimes apply or don't apply. Are there any of those itemized things that we'd like to take out?
Is 6 gonna come out?
That was 6, this has the witness been offered or received any money for treatment or other benefit to testify. We'll
Correct.
take that out.
Yeah, we can
Any
take that
objection
out.
from the state?
Not at all, Judge.
All right.
I think we could probably go all the way down through 10, 7, 8, 9, and 10 should not even include that.
Any objection?
Yes, we would like 8 to remain, but 6.
Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Okay. You want to keep that one in, but the others are okay to take out?
Sure, yes.
Okay, we'll take out 6, 7, 9, and 10. We'll leave 8. Is that okay with the state?
Yes, sir.
And then on the second page, there's a section to give only if defendant testified, so we need to take that out. Just that paragraph. That's on page 27. I know in the standard instruction, I think they have other sections for like child witnesses and things like that. Looks like that's already been taken out, but
Yes, sir.
any other objections or additions or deletions to that instruction on weighing the evidence? Anything else?
No.
Defendant not testifying. Any objection?
No.
Defendant statements.
No objection.
Rules for deliberation.
No objection.
Cautionary instruction.
No objection.
Verdict.
No objection.
Verdict form.
No objection.
Single defendant, multiple counts.
No objection.
Submitting the case to the jury.
No objection.
consensus understanding the agreement?
Yes, Your Honor.
Yes.
What did you say?
So, Yates, so, the two alternates, so, in other words, I'll have them remain in here with any other jurors or something.
So you're talking about what evidence to send?
No. Now, on the evidence that you want to send back, we've got time for you all to look through that and agree to that prior to closing arguments. Is that, you don't do that, I think.
I did get an evidence exhibit list from Madam Clerk. I will send it to opposing counsel. I did send it to them.
Okay, very good. And just let me know what you've got. Can you print out a clean copy? I know we didn't change much. Well, what did we change? Weighing the evidence?
Weighing the evidence and tampering with physical evidence.
And the tamp. If you could just print out a clean copy again, because I don't know if it changes the plain page numbers or not. That's why I don't let it.
I've got a full new copy coming your way, Judge.
Thank you. Anything else the court needs to address then?
No, Your Honor.
All right, I'll let you do that, and then we can do recess until 11:30. All right. All right.
Just get a clean copy, just put it up here. I'll take a look at it, make sure the minutes gets one, and just confirm everybody's in agreement with it. Be recessed to 11:30.
Right.
For the record, the state's present defense counsel and the defendant are present. I have a copy of the final instructions. Looks like the revised final version. And were there any additions, corrections, deletions, or anything from the state or defense on this final revised version?
No, Your Honor. No.
Okay, so this is what I will read to the jury and give to them. Were you able to go over any exhibits that you wanted to send back with the jury? Did you all, do you know what you're sending back?
Yes, Judge. As far as the state is concerned, I think everything can go back to the what was done with the jury. Obviously, there's concern with regards to the videos, them not having the ability to view those, but other than that, everything else can go back.
Okay. And are you going to agree with that as well?
Sounds fine.
Okay. All right then. And earlier we had the conversation, Mr. Davis. I'm sorry, just real quick. When we had the conversation about you deciding not to testify, just to make sure no one's forcing you not to testify. And is that correct?
Yeah.
Okay. And you're making that decision of your own free will. Yeah. Okay, that's fine. All right then. We will ready to bring the jury back and begin closing arguments. Is that correct?
Yes, Your Honor.
Is the defense ready as well?
Yes.
Okay. Let's bring it back. Was there anyone on the jury not able to follow the court's earlier instructions about doing any research, looking up anything, or discussing anything about your service as a juror on the case? Seeing no hands, we're ready to proceed. So, ladies and gentlemen of the jury, both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time. The state is entitled to divide this time between the opening argument and the rebuttal argument after the defense has given its closing argument. Was the state defense ready to proceed?
Yes, Your Honor.
Yes.
You may proceed.
May it please the court?
Yes.
Opposing counsel. Members of the jury. No, no. Those are the last noises that the neighbor heard from Barry Schmalbach's apartment before Barry was never seen or heard from again. Now, members of the jury, you have been here since Monday, and you have seen the state's evidence, and you have seen the state present to you. I apologize, I'm going to sound away so y'all can see. You have seen the state present to you a multitude of evidence, including photos, videos, audio statements. And the reason we did that is because this isn't a simple and shut case. We don't have a body in this case. What we do have is the defendant, and the defendant being the last person who saw Barry Schmalbach alive. The last person who was with him when he said, no, no. And then the actions of the defendant after the 19th, buying duct tape, a tarp, a pickaxe, a shovel, renting an Airbnb out in Montura, which is in Clewiston, disposing of the pickaxe and shovel, a neighbor seeing Barry's wallet, and the wallet then being found in a storm drain a few days later. and then cadaver dogs actually alerting to the smell of human remains in the back of Barry's Jeep. As you're aware, this is Barry Schmalbach. He was born on October 15th, 1966, and his day of death, July 19th, 2023, by the hands of the defendant, Christopher Davis. Now, members of the jury, you are going to see, what you have heard today is that there was no data usage on Barry's phone. Now, this case involves subpoenas that were done to a multitude of agencies, whether it be AT&T, whether it be Cellbrite, search warrants. There is a lot of evidence in this case. And you'll actually get to take that evidence back with you, most of it. Some of it you do have to come out here because there's a computer, but for the most part, you get to take it back with you. And what it is you actually get to see stage by stage by stage what happens at the beginning, before the defendant kills the victim, as well as what the defendant's actions are after he killed the victim, including getting Botox over someone he was just so worried about. There's no data usage on Barry's phone after 9:32 p.m. The last call out from Barry's phone, 8:20, 8:21. The last time Barry is seen alive is on that video from Brecker's Jewelers, 8:29 p.m., July 19th, 2023. The last text out from Barry's phone at 8:30. Now, members of the jury, you heard a voicemail that Barry left for Miguel Blanco.
Yes. Hey, it's me. Give me a call. I need your help. I need to get rid of this fucking idiot. Because I can't take it anymore.
Members of the jury, the state would submit that this call was made to Miguel as he was walking home. A call that the defendant must have heard. A call that the defendant took his actions into his own hands and took Barry's life. The defendant has been charged with these 3 different charges. The state has been able to prove them to you beyond a reasonable doubt. The state has been able to prove second-degree murder, tampering with physical evidence, as well as fraudulent use or possession with intent to fraudulently use personal identification information of a deceased individual. That sounds like a bunch of words, but it really is using someone's credit card or personal information that is now deceased without their permission. And the state gave you a puzzle, and we put the pieces of the puzzle together. And when we put the pieces of the puzzle together, you got the defendant. Now, at the end of the judge is reading you jury instructions, he is going to give you what is known as a verdict form. This is what the verdict form is going to look like. It is going to have the charges. It's going to have guilty, not guilty. And the state would submit to you that we proved the charges of second-degree murder, and we'd ask you to find him guilty. We proved the charges of guilty of tampering with physical evidence. You've seen the axe that he tried to throw away at Ace Hardware. You saw the shovel that he tried to throw away at Ace Hardware. And members of the jury, you heard from Becky Weber that she saw the victim's wallet in his condo. And where was the wallet a few days later? In a storm drain. That is disposal of the evidence. That is tampering with evidence. And we have 8 counts of using Barry's information without his permission or his credit card. Members, that's why you saw so many credit card statements and so much to do with regards to these credit cards. We have the defendant calling every single card number that is in Barry's wallet. And we have him using the card at Target, Publix. He calls PNC Bank, and at the PNC Bank call, which he tried to disguise himself as being Barry, but you heard from Kim as well as Miguel, that's not Barry's voice. That's the defendant's voice, especially when he got excited that he actually got access to it. You also saw him use the card at Starbucks multiple times, Walmart, Seacoast Bank, there's actually a really good picture of him that you see with him actually trying to get money out of the ATM machine. Home Depot and Aunt Teresa Aesthetic Medicine refillers. Now, again, this is a lot of words for basically saying that he did not have Barry's permission to use his credit card or identification information to access his financial records, to talk about his mother's maiden name, social security number, information he did not have permission to have. So we have to prove two elements beyond a reasonable doubt. That Mr. Davis willfully and fraudulently used or possessed with the intent to fraudulently use personal identification information concerning Barry Schmalbach, as well at the time Barry Schmalbach was a deceased individual. We've got different definitions that are going to be given to you as well. So willfully is the first one. Intentionally, knowingly, and purposely. He used the cards. He called the banking institutions. Those were the actions of the defendant. Fraudulently means purposely or intentionally suppressing the truth or perpetrating a deception or both. Well, let's see. He bought a duct tape. He bought a tarp. He rented a Airbnb in a rural area after searching for rural areas after his boyfriend went missing, after the noises in the condo were heard. He is fraudulently using this information. Barry is dead. Personal identification information. Basically, this can be social security number, credit card, bank account. There's a variety of different things it can be. Humorously enough, it says mother's maiden name. We've heard that on the PNC bank call. Or even possessing it. Guess what? Having it in your handy little wallet, that's possession. And having control. So we have to prove that he knew of the existence of the personal identification information and intentionally exercised control over that personal identification information. Well, what's interesting is one of the cards that he ends up using, the PNC bank card that he actually gets access to, the state would submit to you after he gets access to it, he puts it back in Barry's wallet because it's found in Barry's wallet in a storm drain. You can see at the very beginning when he is at Walmart, that wallet of the defendant is predominantly empty. By the end of it, at the search warrant on July 24th, he's got a multitude of Barry's credit cards in there. How did he get Barry's credit cards? Because he took them without his permission after he killed Barry. Mother's maiden name, access device, social security number, credit card or debit card number. That's personal identification information. And we have that over and over again in this case. At 8 different places. Tampering with physical evidence. This is where the state has to prove 2 elements to you. That Christopher Davis knew that an investigation by a duly constituted prosecuting authority or law enforcement agency of the state was pending or about to be instituted. Okay. Well, when you get called...
Yes.
Yeah.
By a duly constituted prosecuting authority or law enforcement agency of this state was pending or about to be instituted. Well, a missing persons report was going to be pending when Miguel Blanco said, okay, you need to file one. We haven't heard from Barry. Or alternatively, I'm going to file one. Guess what? Miguel already did, or he was going to. That is a pending investigation. Ultimately, it turned into a homicide investigation, but it was still pending. Now, after he does a missing persons investigation report, and Miguel does one as well, then it becomes about to be instituted. Because guess what? It's going from a missing persons to a homicide investigation in this case. That Christopher Davis altered, destroyed, concealed, or removed any record, document, or other item with the purpose to impair its veracity or availability in the investigation or proceeding. Technical difficulties, I apologize. So, we see in this particular frame Mr. Davis with the shovel and the pickaxe in Clewiston, where he purchases it with cash. We see him at Ace Hardware at the very back near the dumpster, taking the shovel and the pickaxe and throwing them in the dumpster. And when he gets caught by Carl Hewitt, what does he do? He leaves the pickaxe next to the dumpster. This is tampering with evidence. He was trying to get away with just hiding where he put Barry's body. Tampering with evidence. He left behind the pickaxe, so law enforcement couldn't find it. A pickaxe that was bought at an Ace, so let's just put it back at an Ace. No one will think anything of it. Within 25 hours of purchasing it. And then once it's instituted, Becky Weber sees that wallet. She knows it's Barry's wallet. Where does it end up? A storm drain. That happens to be on the walk that the defendant and the victim take together on Beach Parkway. Now, to prove the charge of second degree murder, the state has to prove to you 3 elements. That Barry is dead. We hit this in jury selection, as always. We talked about this in opening, but we talked about it through all of our witnesses. We don't have a body in this case. What we have is every piece of the puzzle of the Statue of Liberty. We're not missing the flame. We have the entire picture for you. Barry is dead, and he's dead because of the actions of the defendant when the defendant killed him and then took every step possible to hide the evidence and to get rid of the body. The death was caused by a criminal act of Christopher Davis. There was an unlawful killing of Barry Schmalbach by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. And the act is actually defined. It includes a series of related actions arising from and performed pursuant to a single design or purpose. Purpose is hiding the evidence, getting rid of the body. Purpose is to do what he wants to do because he knew Barry was going to leave. An act imminently dangerous to another and demonstrating a depraved mind. If an act or a series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. Slamming him around. No. And the whimpering. He killed Barry that night in the condo. And that's exactly what his neighbor heard. It's done from ill will, hatred, spite, or evil intent. Well, let's see. We have text messages that say, I'm tired of his BS. We have a voicemail. I need to get rid of this fucking idiot. He knew he was going to get broken up with. Barry had warned him. Stop the drama. Your insecurities are going to be the end of us. And the defendant, by his own words, told Becky Weber, I think he's going to leave me. I'm not going to have anywhere to live. Barry's demise was the defendant, and the defendant's insecurities, and the defendant's ill will, hatred, spite, or evil intent. And I apologize, I clicked one. And is of such a nature that the act itself indicates an indifference to human life. Well, he gets slammed around, then we hear no, no, and then we hear whimpering. At no point does the defendant call 911. At no point does the defendant report Barry missing until 5 days later. It's okay though, because he went to sleep because he had drank too much when he got home that night from the bar, and he woke up at 4 a.m. and Barry was gone. That's not what his digital footprint shows, ladies and gentlemen of the jury. So our timeline. The best way the state could present this case to you was by day by day. And the reason we did that is because of the multitude of evidence in this case. Because there's a digital footprint. There is a physical view of the defendant over and over again, searching places, going to places, buying and doing things to hide what he's doing. And members of the jury, we start on July 19th. And on July 19th, we find out that the defendant and the victim went to Cruisers, that there was an argument, that there was slamming around, no, no, no's and whimpering. There was a Jeep chirp 5 to 10 minutes after the neighbor heard this whimpering. There was a ping of the victim's cell phone, the last time being in a 5,000 meter location of the condo at 8:41, and there was the defendant going to Walmart at almost 10 o'clock at night and buying 2 rolls of duct tape, a tarp, and a bottle of chocolate milk. And what we did is we used Detective Bearman as the narrator. And on that particular day, we heard from the neighbor Ruth. We actually heard from a lot of neighbors. We heard from a lot of family and friends. And guess what they all said? Barry would never not respond. The only person that ever said Barry didn't respond is the defendant. And we already know that based on the cell phone records that we have and the digital download of his phone, that's not accurate. You see the back and forth conversations between Barry and the defendant. It's just not what the defendant wanted to hear. Barry was meticulous. He was kind. He was loving. He was clean. Nothing was out of mess. Heck, Hurricane Ian destroyed the area, and Barry's concern was cleaning the outside of his car. That's how meticulous he was. His job in that Jeep were his life. He loved his friends and family. He kept in constant communication with them, calling and texting, telling them, hey, I'm going here, I'm going there. Even if he's in another country, he's still responding to a friend of over 40 years. He had family members in the area that he would have a weekly date with, basically, because he's an elderly man. And none of those friends or family have heard or seen from Barry since July 19th, 2023. You heard from the bartender as well as a friend that were at Cruisers that there seemed to be an argument. Barry left, the two parties left separately, and Chris chased Barry out of Cruisers. You heard from Rosalie that she had gotten that I'm tired of the BS text. You heard from Miguel. He had gotten that voicemail that you heard. And the funny thing about Miguel is, members of the jury, I told you at the very beginning during our opening statements that Miguel is going to say over and over and over and over again, that's Christopher Davis, that's Christopher Davis, that's Christopher Davis, that's Christopher Davis's voice. And Barry is only seen in 3 of those videos. And it's the 3 before the defendant killed him on the walk back from Cruisers Bar on July 19th, 2023. So we have the defendant in the victim's condo. We have cruisers, which we know they go to. We know that at some point they pay and leave. We have the receipt and evidence. You guys will have the ability to take back the evidence with you and actually look at it and go through it if you wish. We see that Barry's the one that actually made the purchase, and he used his Amex card. So we know Barry had his American Express card on him when he paid, because he paid without Chris around, because Chris was in the back room. Barry left without Chris around, so Barry took the card. How do we know Barry took the card? Well, it's found on Chris's possession on the 24th, after he killed Barry and tossed the wallet. He didn't toss that card, but he sure as heck tossed the PNC card that he also used. We have the fact that they're walking by budget blinds. We have the fact that they're walking by Monarchas. And we have the last known sighting at Breakers Jewelers. That's the last time Barry's seen alive. 8:29 p.m. Now, we talked to his friend of 40 years, Rosalie, and she told us that she talked to Barry all the time. She texted him, called him. They've been friends for 40 years. They've even gone on a cruise together, and Barry has never once given her his credit card. They actually used hers when they went on the cruise years ago. That's how long they've been friends. Barry's had that same number for as long as she can remember. Heck, as long as anybody can remember. But that becomes interesting, because at some point, Barry doesn't remember his cell phone card. Sorry, his cell phone number. So the text messages we see from Rosalie, remember she's an hour behind us, so we have to change it from Mountain Standard Time to Eastern Standard Time. And we see that on July 19th at 7:06 p.m., she texts him. Barry responds at 7:06 immediately. I am at the bar with my BF, but I am so done with the BS. Please call me tomorrow. Space, period, space. I miss you so much. Space, period, space. Okay, will do. Love you. Hang in there. And then she gets an impromptu response that was not elicited. It's okay. I love him. Period. And okay is spelled differently than the okay at the very top. And that comes into play because when you look at States Composites 40A and 40, you're going to see Barry only responding with okay as OKAY, and Chris responding with okay as okay. It is a pattern. It is how people text. It is how Barry texted. Space, period, space. OKAY. Okay. Space, period, space, and then Chris responding back with the word, period, space. Not the same as Barry. You can go through those text messages. When Barry doesn't have a punctuation, it's a run-on sentence. Or when he does, space, period, space. Also, Barry doesn't use commas. Chris does. And something he never would have told Rosalie, but maybe he'll tell other people, is that he loved him and he'd had a few. That's not something he would have told Rosalie. That may have been something he would have told his cousin, but not Rosalie. You're also going to be able to look at a variety of messages that the state brought in 40A and 40. There's a message back in June 15th, 2023. It's from Barry. I have bent over backwards for you and you cause drama. Space, period, space. I want drama free. If you can't do that, then it's over. Space, period, space. I love you, but I am not in this for your drama. And we see Chris's response. I love you more than anything in this world, comma. And it feels like you're ripping my heart out right now, comma. But you're not going to threaten to leave me anymore, Barry. I love you. So Barry had threatened to leave him in the past. And that night, on the 19th, he heard him tell Miguel, I'm done with this fucking idiot. Barry responds. And remember the dirty, you can see Barry's response times. It's within a minute. Because Barry did that. Barry responded instantaneously. If not, it was the same day. It was not almost 2 years, which is what it is now. Nobody has seen Barry. No one has heard from Barry. No one has talked to Barry. No one has texted Barry because Barry is dead. And then we see also some more text messages. This one's from Barry. Again, about Chris's drama. Again, space, period, space. Stop the drama and we can be happy, but right now I am done. We see Chris's response. We see Barry's response. I did not break up. I do not want drama. There's no comma because it's run-on sentences. You can look at the identity of how somebody responds to you to know who it is. I can't do this anymore. Either get on board or leave the ship. That is a text message Barry had sent to the defendant. Again, run-on sentence, not proper punctuation. We continue. Again, space, period, space. Space, period, space. And then we have Chris using commas, proper punctuation. Then we go back to Barry, space, period, space. Over and over again. Now, members of the jury, I'm going to direct your attention to the June 15th, 2023 text message at 7:24 p.m. It's from Mr. Davis. I love you more anything in this world, and it feels like you're ripping my heart out right now, but you're not going to threaten to leave me anymore, Barry. I love you. Barry was leaving him, members of the jury. And then we see again, okay and okay. We see the different spelling. Over and over again. Then we see a text conversation, and what we did was we put Christopher in red and Barry in green, except for obviously the bottom text message, which is an excerpt from the 40A and 40 composite. And it's Christopher saying, if you block me, I will call you from a different number. What did we hear about from Jackie Fordham, the forensic tech, as well as Bryce Bearman, the detective? That the text message that was supposedly on this watch that talked about an Italian dinner, it was from a VIOP, which is a number that someone is using to spoof, to scam, to do something of that nature. It did not come from a known phone number. Baby, I'm telling you that I am sorry. I do not want to argue. I just want to speak to you. I want to go to bed, please. Baby, I'm in love with you and you're in love with me. I'm freaking out. I just want to hear your voice. Baby, you know I get emotional. I do not want drama. The only reason that there was drama is that you're not answering my phone calls and I don't understand why. Barry's response, he's visiting his cousins. I am with my cousins. Stop it. God damn it. Stop it. Barry, one more time and I will block you. If you block me, I'll call from a different number. The reasons why Chris was telling the officer, oh, he's done this before. He's gone to California and Wisconsin and here, and he stopped talking to me. No, he didn't stop talking to him. He had to tell him over and over and over again, stop it. I'm done with the drama. Stop it. I'm working. I'm with family. I am doing something. The defendant did not like those answers, though. So what does the defendant do? Within an hour of no, he searches Walmart near me. He gets in Barry's Jeep, chirp, chirp, and he goes into the Walmart parking lot in Del Prado Boulevard in Cape Coral at 9:38 p.m. But he's not there with anybody. He's by himself. We see him walking in the same clothes that he was wearing earlier that day. And we see him buying a tarp, a 12 by 24 foot heavy duty tarp, and we see his wallet. And it looks empty, members of the jury. We know what he bought too because of the receipt. Tape, tarp, bottle of chocolate milk. And guess how he paid? In cash. You'll notice a trend. He pays cash for the duct tape and tarp. He pays cash for the pickaxe and shovel. He pays cash for the dolly. Because there's not a trail as much of cash. But Big Brother's always watching, members of the jury. And that's what we have in this case. A video of him doing every single one of these actions. Duct tape, tarp, 9:57 p.m. Supposedly when he's asleep, because he's just so drunk. Now, the defendant does try to call Barry's phone. I want to say he calls between 16 and 17 times. And the funny thing is he stops calling Barry's phone once he reports Barry missing. He's so worried about Barry being missing that he stops trying to contact him. When the defendant calls Barry's cell, it starts at 10:19 p.m. It's routed to Barry's watch as a call forwarding not reachable. Then it sends the call to a different number when the device is not reachable, and it goes to a voicemail. When you look at the cell phone records of the victim or the defendant, it'll be the watch, it'll be the phone, it'll say forward, and it'll be the phone. It's because the two devices are bouncing off each other, and what happens is it goes to voicemail. This happens over and over again until Barry is reported missing on the 22nd. Now we move to Thursday. On Thursday, you heard from the narrator, Bryce, again. He's the best person to walk us through the timeline of the defendant's actions because he followed him. You heard from Cindy Thomas, who deals with Barry and Chris regularly, who states she asked Chris, where's Barry at? What was his response? He's working. Huh. It's different than what he told other people. You hear from the neighbor, Kimberly Zanzatali, as well as Miguel Blanco. You also hear from Brian Jobe that there's only 3 men in the apartment complex or condo complex at that time. Him, Barry, and Chris. We have Starbucks working, we have him going to Lowe's, we have him buying a hand cart. We have him wearing Barry's watch, we have him going to Target, we have him going to Publix, and we have the PNC bank call. And guess what? We have the defendant using Barry's card over and over again at Starbucks. How do we know it's Barry's card? Well, Barry's name's on it, the defendant's not. We also know it's Barry's card because we have Barry's records over and over again. And guess what? Barry's nowhere to be seen because Barry's dead by the defendant's hands. Now, we see him at Lowe's. We see him with a hand cart he paid in cash for. Huh, maybe that won't be tracked. Then we see him go to Target. Oh, there he is wearing the watch. Barry's watch. Then we see him go to Target. And what does he do at Target? He made just 2 purchases. And when you look at it, they're small purchases. It's $1.50 and $2.56. Then he goes over to the ATM with Barry's information. Stands there for a while, doesn't pull anything out, and leaves. Then we go to Publix where we buy fried chicken and diet tea. Guess how we pay for that? With Barry's credit card. That's the 9617 card. Members of the jury, the next glaring...
Hi, my name is Melissa. Can I get your first and last name, please?
This is Barry Schmalbach.
Thank you. And how can I help you today?
Let me just add my card to the phone.
Okay, we'll be happy to assist. Let's start by getting your social security number.
Yes, absolutely. 252-6607.
And what is the last four digits of the card number you're And is it for Apple Pay, Samsung Pay, or Google Pay?
Apple Pay.
Okay. And can you verify your address on file? You know your mother's maiden name? What is your date of birth?
10/15/1960.
Thank you. The phone number you have on file?
Yes, it is 708-31. Hang on, oh boy, I never remember my own phone number because it's just damn cell phone. I'm sorry. 708-341-0729. 341-0729.
Thank you. And the last piece of information I need is the 3-digit security code on the back of the card.
Absolutely, 49.
Thank you. Wow, that still doesn't look like it's connecting. Okay, looks like it wants me to send you a text message. That number that you provided, is that a valid phone number or cell phone to get a text message at or phone call?
Yes, that's a valid phone number. What I will say is I've been having a problem with my text messages. Is there any way I can call me?
Yeah, I can do, it should give me an option to do it as a phone call. That way you can put me on hold, grab that code, and then come back to me.
Okay.
Right, let me just put that phone number in. Okay, and you said you wanted it as a voice call. Okay, just hit that. You should be getting a phone call with a 5-digit passcode.
Two 26015.
Thank you. Perfect. Okay. Got you verified. Verify that card. All right, we got it verified. I do apologize it took so long. Anything else that we can help you with?
No, that is it. Thank you. And it should be, so it'll be ready in the wallet now?
Yes.
Oh, it says ready already. Oh, that's amazing. Okay, thank you.
You're welcome. Have a good night.
You too.
Bye.
Now, we showed you the PNC bank records, that Barry's name is on the account, and nobody else. And where is that card found? It's found after Becky Weber sees the wallet in the condo 2 days later in a storm drain. And we know it's there because it's that blue PNC card. The blue PNC card that when you turn it over has a phone number on it. The same phone number he calls. Members of the jury, you also have to remember the searches that Chris did that night. What did he search for on the night and early morning of the 19th and 20th? Cell phone repair. Screen repair. The state would submit to you that the reason he had to do that was because the phone was broken, the screen. So he needed to get the call because he couldn't see the text. Now we move to Friday, July 21st. And about 4 a.m. that morning, we hear what happens when Brian Joe hears something. We see a picture of the defendant with Barry's Jeep getting gas. We see the defendant renting an Airbnb using his brother's name. We see the defendant going to Lewiston, buying a pickaxe and shovel. We hear from one of his friends, Tom Wilson. And again, members of the jury, his friends. He never would leave and not take his phone, his wallet, his identification, his passport. Tom and Barry have been friends for years. They worked together at Restaurant Depot. And Barry never gave him a card after having been friends for so many years. It's consistent. Family and friends, he never gave them a credit card. We also see the defendant going to see Coast Bank and pulling money out. The reason we know that is we, one, have the video. Two, we have the credit card statement showing he did it. We see him going to Walmart and buying air fresheners, an air freshener that is found in the back of the Jeep after he tries to clean up. We hear about the apartment being in disarray because Miguel and Tom went in it when they saw the packages and hadn't heard from Barry. And they had the key because he had a medical condition. So let's start with Brian Joe. 4 a.m. in the morning, he hears something heavy being dragged in plastic. Well, let's see, the defendant, upon a neighbor hearing no, 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 and whimpering, goes to Walmart and buys a heavy-duty plastic tarp and duct tape, members of the jury. Brian Joe hears that heavy tarp being drugged. Brian Joe sees that the light that they installed after Ian, which is one of those hanging lights, industrial construction lights, is off, which is weird because Brian's one of the ones that actually fixes those for the community. Nobody else really should be touching those lights, and it was working before. Guess what? It goes back on. And guess what's found on that light? The defendant's fingerprints. He sees the defendant when the light goes back on, coming up the stairs. Same outfit as the person that was dragging the heavy object in a tarp. Again, nobody's here from Barry. No one has seen Barry. There's only 3 males in the complex at the time. 2 of them, Chris and Brian. Barry hasn't been seen or heard from since the 19th. You're going to hear about, or you heard about, black and yellow boxes that Brian Jobe sees Chris carrying, which are consistent with the black and yellow boxes that Roxanne Hernandez finds at the Airbnb. You're going to see the same clothes as when the defendant goes to Daybreak, when he goes to Walmart in Lee County and Cape Coral. Brian Jobe also identified at the Daybreak gas station, that being Chris and that being the victim's vehicle. Same clothes as he saw the person who was dragging the heavy object, as well as carrying the tarps. As well as carrying the boxes. Then we go to Walmart, here in Lee County, where the ATM this time works, and we know it works because we see him pull out something. We also know it works because it goes to the Capital One credit card. We see that he pulled money out of that ATM. Not money, that was his, no, that was Barry's money. Because he had Barry's Capital One card. We also see that while he's there, he buys air freshener. And the air freshener is a spray cleaner too. That's found in the Jeep. Now we go to the Airbnb in Clewiston. And we see and hear that when the owner of it went in, it was full of sand and debris. She likened it to a kid playing in the beach with a sand pill and dumping half of the sand in the shower and half of the sand in the tub. And debris that is very consistent with the items and the wood in the rural area that's out there, the raw Florida, because that's what Ventura is. It's a raw Floridian area, untouched, acre and a half lots as far as the eye can see. She sees furniture moved, and she knows that it wasn't there before all this debris because her and her mom cleaned the house themselves. They've been doing this for 11 years. And during this 11-year period, she's never had someone talk this much to her. Usually it's like, hey, I have a problem, or hey, can I have the Wi-Fi password? Nope, we got back and forth conversation of a play-by-play of what he is doing when it's convenient. And who is he? Well, supposedly it's Tyler Gamble, but the defense attorney submitted during cross-examination that it was Christopher using Tyler's account. But we also know it was Christopher because she saw Christopher running after he told her, hey, I'm gonna go for a jog or a run, and then I'm going to check out. She doesn't see Tyler Gamble running, who has a profile picture. She sees the defendant, and she identified the defendant in the courtroom when she testified. That is the person that was at the Airbnb. She lives across the street. We also know that he had Tyler's information, which again, the defense said he did. He used the account. We know it because it's actually saved on the phone, the password as well as the user ID. But members of the jury, we also hear that between 3 and 4 p.m. on the 21st, she sees something unusual, which is clothes being hung outside on the banisters for somebody that's staying there for a night. After the defendant went radio silent for 3 hours. No calls out, no calls in taken, no text messages out, no texts in, no data usage during those 3 hours. 3 hours where he starts at the Airbnb, miles down the road, 6 miles down the road, which is a 5 to 10 minute drive depending. What's interesting is he has this back and forth with Roxana Hernandez. And he says things like, hi, I'm visiting my family and just looking for a nice relaxing place to stay while I travel. It will be just me. Then he says, okay. Look how he says okay. Okay. Awesome. Thank you so much. I will go ahead and head over soon. Good morning. Thank you so much for the great stay. I just want you to know I am going to get some breakfast and come back and go for a run before going home. The forests are so beautiful and the countryside is so relaxing. I will be checked out by 10 or 10:30. Thank you again. Thank you. Let's see. He then says, thank you. I'm heading out to run now. Yay! I will message you when I leave, and your home is very beautiful, by the way. 5 stars from me. I'm leaving. Thanks again. I wanted a suite, but I could not find the broom. I had a great time. I'll be back to see my brother next month. Could I reserve this place for a week and bring him and his wife? They will love it. At what point during those text messages does he say, hey, I'm not Tyler Gamble. I'm Christopher Davis. Nowhere. Instead, he continues with information that is misleading, using his brother's account, pretending he's his brother. Then we have a wonderful image of his face. What do we have him doing? Pulling more cash out. This time at Seacoast Bank in Clewiston. Using Barry's card once again. What does he do after he goes to Seacoast Bank? Well, he goes to Ace Hardware. And we see him in Ace Hardware 10:37 in the morning, walk into the cash register with a pickaxe and a shovel. That was the jury. He lives in a third-floor condo building. He's out in the middle of nowhere. Opposing counsel made an argument, something about a mud park. Guess what? That mud park's been closed since 2020. Maybe he wants to go mudding. Well, that Jeep didn't look like it'd been mudding. It'd been in the sand. White sand. What's interesting is, guess what he pays here? He pays in cash. Once again. And guess what he's wearing on his wrist? Gary's watch. You heard from the teller that was Christopher Davis. She even identified him in court. That was him. Then we moved to Saturday, July 22nd, 2023, where Miguel contacts him and tells him to file a missing persons report. We find out that he gets rid of the shovel and tries to get rid of the pickaxe. Pickaxe that he's had for less than a day. What's interesting is he tries to get rid of the pickaxe at the same place that he bought the pickaxe, just in a different area. I wonder why. We also have the Airbnb back and forth notes. We have him calling the non-emergency Cape Coral number, talking to the person. You heard that call. You watch the body-worn cam with Officer Dan Lilly with what the defendant says, how the defendant is acting. As well as you hear from Becky Weber, who's the neighbor who happens to see the wallet and who the defendant tells, I'm scared he's going to break up with me and I'm going to get kicked out. So after the conversation with Miguel, before he calls the non-emergency number, what does the defendant do? Oh, he goes to Ace to dispose of the axe and the shovel. And what does he drive to Ace? Oh, he drives Barry's Jeep. Barry's Jeep that was clean before he went to Montura, now has stuff all over it. And what's interesting is his location, when you look at states 40 and 40A, shows him in Cape Coral at 11:26 at his condo. And he's at Ace Hardware, I believe it's 12:30ish. He's got an hour, so he talks to Miguel, goes to Ace Hardware. We find out that he gets confronted. He takes a couple items with him, but he leaves the axe because he's trying to get out of there. That was collected by Cape Coral, an axe that is in front of you today, members of the jury. Heavy enough to break up hard ground, to help dig a hole. The defendant called the non-emergency number to do a missing persons report, and overshared during that non-emergency call by giving him a play-by-play of what's going on. Kind of his MO throughout any time he talks to somebody. 7/22/2023 at 17:19:35. He calls Cape Coral Police Department. Remember, you have to do the conversion when it comes to the cell phone records. You have to do -4 to make it into Eastern Standard Time. That is 1:19 p.m. Talks to Miguel about 11:30, disposes of whatever he can. At 12:30, calls Cape Coral. Yes, he does call law enforcement at LCSO. You'll see the Lee County Sheriff's Office number, but 20 minutes later is when he calls the Cape Coral number that he's been advised to call to do the missing persons report. That's still a half an hour after he drops off the pickaxe and shovel. Then we have Dan Lilly, whose body worn you got to watch. And remember, the defendant's so worried the entire time. Christopher says, basically, hey, this is my name, this is my date of birth. He gives the date of birth of 6/9/1989. The officer actually repeats it when he's calling into dispatch. Last name is Davis, Delta, Alpha, Victor, India, Sierra, white male, date of birth is 6/9/1989. The defendant is standing next to the officer when the officer does this. On the stand, Becky, one of the neighbors, said that the neighborhood would figure out who would take Bear to the airport. He would never take an Uber. It's like Melrose Place. They knew what was going on. They all cared about each other. Honestly, Melrose Place might have had more drama than the neighborhood did, but they were there for each other. The defendant says the airport, yes, every time he goes to the airport, he Ubers. Every single time. He never takes the car out of town because he leaves it here. Okay, and then we've got the officer and Chris having a conversation. And so I don't know what to do, but I want to go ahead and file the report because his friends are now saying that, like, I need to because he's not responding to them. And then the officer says, friends, the ones that he went to the Italian dinner, anything like that? Chris, no, not the Italian dinner. The Italian dinner, I turned on his fucking Apple Watch. Here, I'll show you. Officer says, well, do you have something that tracks him? Chris says, basically, he left the watch here because he knows I've tracked him in the past. He left the watch here because Barry's not with us anymore. Barry's dead. The watch that Chris is wearing over and over and over again in the videos as well as the photographs you've seen from the 19th until the 24th when it's collected. How long have y'all been together, Chris? Almost 4 months now. Cinco de Mayo. Let's see. June, July, August, September. That's not 4 months. What is it? 2 months. Would it be okay just to like wait a day or two and then actually just like do all this? Because like I don't want to file anything and then he shows up. If he's not here by Tuesday or Wednesday, I'll just call you guys back. Huh. He did tell the officers that Barry tried to come into the apartment and drop off packages, but it wasn't Barry, it was Miguel and Tom. And what does the defendant do after this? Guess where he goes? He goes to Home Depot. Guess what he buys? A swing lock, like the kind that prevents somebody from coming into your hotel room, and a deadbolt lock to change out the locks of the condo. The defendant, I'm beginning to get in the middle stages of worried, and what if he's not here next week? Like, what if he's not here tomorrow? Well, the officer says then you can call us back and file a missing persons report. Went back and forth. And then Chris says, I mean, he took some clothes, obviously. Like, there's some clothes and stuff that's gone. That's weird, because when you look at the apartment pictures, what do you see? You see Barry's medicine. You see Barry's watch. You see Barry's passport. You see Barry's toothbrush. A man that's so meticulous and clean forgets his toothbrush, forgets to bring his clothes, forgets to bring his identification, forgets to bring his wallet. Members of the jury, you get to use your common sense in this case, and it doesn't make sense. It's because the defendant killed him. And remember how I pointed out that he told the officer 6/9 of 1989? Guess what? His birth date is 6/8 of 1988. Another discrepancy. Now you hear from the friend, Becky Weber, who tells you she sees the victim's wallet. That wallet is found in a storm drain on the same street that Barry and Chris live on. A storm drain that's on their daily walks to Starbucks. A wallet that we know he had with him when he was at Cruisers because he pulled a credit card out of it to pay the bill. Credit card that is later found in Chris's wallet when the search warrant is done on the 24th. He tells Becky, I'm worried about him breaking up with me and kicking me out because I'm unemployed. What am I going to do? Becky flat out told them. Barry's not like that. You know that. Because that's the kind of person Barry was. Kind, friendly, willing to help out his friends, willing to help out his family. Heck, he employed one of his family members. He's had the same friends for years, one since grade school. Then we move to Sunday the 23rd, where we hear that the defendant goes to Home Depot and buys a Sentry safe, the swing bar lock, and a deadbolt lock. Well, the Sentry safe, we find out, he does searches for. He tries to figure out how to break a code. He tries to search for the exact same safe that the victim has in his apartment. The exact same safe that has fingerprints all over it because the defendant tried to get in and couldn't. He buys that deadbolt lock because he knows Barry's not around, but somebody else is poking around to make sure they stay out. We see again, he uses Barry's credit card. He uses Barry's credit card to buy the fire safe, buy the door guard, and buy the lock. Again, Barry's nowhere around. Why would you need a safe? Why would you need to change the locks? We have his search history, his phone calls, and there we have him, walking out, so worried. Then we find out the next day from the Starbucks employee, when he buys another Starbucks with Barry's credit card, that he's now changed. That Barry's been missing for a day or two. This is a hate crime. He goes to Anna Teresa's Aesthetics, gets filler done. So worried that he has to get his filler done because his boyfriend's missing. He talks to law enforcement. They do search warrants of his house, of the car, of the wallet, of the phone. He heard from his friend as well as his cousin. This is not Barry. Barry would always respond. And they haven't heard from him in almost 2 years. So what did Cindy Thomas tell us? Well, initially, he said he was working. Remember on the 21st? Or sorry, excuse me, 20th. Now he's changed and he went to a friend's house, he took an Uber, he didn't come back the next day. This is a hate crime. He's gone for 1.5 to 2 days. Members of the jury, he's been missing since Wednesday. 1, 2, 3, 4, 5 days. But it's okay because the defendant was so drunk he went to sleep, and when he woke up at 4 a.m., Barry was gone. Well, what does the defendant do? He also goes to Pretty Nails. We know he got a pedicure because when he went and got filler, he was telling Laura Standiford about his pedicure. Pretty Nails, he does searches on his cell phone for it, then he uses the card again. He does searches on his cell phone again for Anna Teresa Cosmetics. We see that when he goes to Anna Teresa's Cosmetics, he uses Barry's Amex card. $1,454. When was the last time that credit card was used? At Cruisers, when Barry paid the bill. We know that he has the card because that card is found in the defendant's wallet. We also know that it was in the pink trash can, the giveaway bag. The pink trash can that also included extra parts of duct tape, a cover for a hand cart, which is very consistent with the duct tape he bought at Walmart and the hand cart that he bought at Lowe's, as well as a cell phone case that's identified as Barry's cell phone case in the trash without the phone. Now, something interesting that Laura Standiford said was he was excited, he was giddy. He had made an appointment back in May. She also said he didn't have to put a card down, there was no deposit, nothing. He called the morning of on the 24th to make his appointment. His boyfriend is missing. His boyfriend hasn't been heard from multiple people, and he's so worried that he goes gets his face injected. And he throws the bag away in the same place that he's thrown duct tape, cover of a hand tarp, and Barry's cell phone cover. Now, members of the jury, on the 19th, you see the wallet at Walmart, and then on the 24th, when they do the warrant, and they search it, well, it looks a little bit more full of credit cards, doesn't it? What's interesting is this particular card. That's the American Express. The American Express that was used to pay for Botox, excuse me, not Botox, filler, as well as at cruisers. Not there. It's not there because he took it from Barry after he killed him. And what do we find in Chris's wallet? Credit card after credit card with Barry's name on it. None of them belong to Chris. They're all Barry's. Now, he tells law enforcement that when he got back from the bar, he went to sleep. And when he woke up, Barry was gone. But what's interesting is we see him at Walmart, and then we see him doing a cell phone. And he does a text message back and forth with someone who says, send me a pic. So what does Chris do at 10:50 at night? He sends a picture of himself. He's asleep because he's so drunk. He searches for every place he goes. Walmart, Ace, Lowe's, Publix, Anna Teresa's Cosmetic, Screen Repair. He was searching as he went because he killed Barry and he was trying to figure out what to do next. The entire time, as you heard from Jackie Fordham on the stand, he's talking to other men. He is messaging people. He's so worried, but he's not acting like that in public. And then when the officers ask him about the scratches on his body, he says, oh, it's because I was trying to harness my cat. Well, did they find a harness? Nope. Did they find a leash? Nope. They even checked the trash. And the trash is interesting because they're the only pink trash bags. No harness there either. But what those scratches are consistent with is being out in a wooded area, walking through briars, walking through brush, walking through true old Florida. Then you hear about the finding of Barry's wallet, and we also heard from Jennifer Monaco, who was one of Barry's close friends, who had a weekly appointment to speak with Barry. Though she talked to him more than just that, but it's something they never missed. She hasn't talked to him since July 19th, 2023. And where do we find the wallet? Well, not sure. Saw something reflecting in a storm drain. Him and the other technician pulled up the storm drain and found the wallet, Barry's wallet, a wallet that Becky Weber saw a few days before inside the condo. Then we go to July 31st, and we hear information such as they had two different cadaver dogs come out to Cape Coral, and they took 3 employees' cars. They didn't show the cadaver dogs what car they were supposed to alert to. The cadaver dogs didn't watch each other. it was blind. And what did both of those dogs do? They did alerts and responses to the Jeep. The Jeep had human remains in it, and they were Barry's human remains when he was transported from Cape Coral to Clewiston. Now, opposing counsel has said multiple times that Barry was talking to other men. There was an open relationship, that Barry was on Tinder, on Sniffies. Well, what's interesting is when Sean Rippendorf took the stand, I asked him, was Barry on Grindr after the Cinco de Mayo party? No. And what did Chris do? He had to message Sean to get Barry's phone number to be able to call Barry. He did the searches for broken screens. Never found any broken screens. What they did find was an empty cell phone case. The defendant, though, had hookups, Tinders, porn websites, him chatting with different men, though, on the 19th and since the 19th. This was Barry's first known relationship and his last. Whether this was open or not, the defendant is the last person who saw Barry alive on July 19th, 2023. Barry Schmalbach. We heard from the neighbor that there was slamming, being tossed around, no, 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 whimpering. She got the chills. She thought she heard a last breath. Members of the jury, the state would submit to you the defendant is guilty in all charges. Paid for cash for the tarp, the duct tape, paid for cash for the dolly, paid for cash for the pickaxe and shovel. We'd ask you to come back with the only just verdict in this case, the verdict of guilty in all charges. Thank you.
We proceed when you're ready.
Please, court, counsel.
Everybody okay on
Thank you, ladies and gentlemen, for your time and attention thus far. It's kind of like in the opening statement, I said it's a preview, and then during the witnesses and items you received, reviewed, heard, accepted into evidence, that's the actual evidence. What I will say is truth is stranger than fiction. Kind of hear that phrase throughout our lives because things we see on the news and we hear from friends and things you just can't believe that happened. And in this case, we've heard about Barry and his heart condition and the medications you can see photos of, and you can tell some of the medicines, one was tramadol, a narcotic, he was prescribed. Continued drinking alcohol to the point of a neighbor's concern for his well-being because he had been in the hospital, had these heart problems, he had this medication, yet he still consumed so much alcohol. To the point a neighbor, not even like a real close friend, said to him, like, hey, you want to do something about that, I'm concerned. Injectable medicine, syringes, needles he had for the medicines he needed. And bear with me for a moment. I'm going to ask you to infer, which I believe the state has asked you to do the entire time, is take these items of evidence and then infer from them as to what took place. And you heard from the neighbor lady who was there and heard some noises, and it sounded like it was a brief period. She heard some things. It didn't rise to the level of calling the police or 911 or being that worried or going upstairs and knocking and checking. Just with some gay men, you know, I'm kind of stay out of it. Heard some banging or some noise, and then somebody saying no. And that was it. But it was like a week or two later, she talked to law enforcement when they came around and checked with the different neighbors. But up to that point, it had never concerned her to reach out. It was never anything that serious. And maybe as time has gone on, this case has gone on, it's become more so. I don't know. But at that point, she didn't feel compelled to reach out or go up there or call anyone or do anything with it. So infer they get back. They had been in cruisers, we know that. And then they walk back and say there is some argument about tracking whereabouts, and because there's concerns if he's seeing other men, and being done with this, and Barry's going to leave. And Chris is like, no, don't go. And then they're both drinking. They're both probably 2 hours of drinking, it seemed, from their seat for like $100. Nobody mentioned eating anything, so that's all alcohol. And it's at Cruisers in Cape Coral, so they're probably not $15 a cocktail. It's probably, you know, much lower than that, so they probably consume quite a bit. And Barry leaves and goes wandering down Beach Parkway, and if you heard, Beach Parkway goes kind of through the river in Cape Coral, and then there's canals all around it. And say someone's coming down Beach Parkway and mows them down because they're drunk too, a DUI manslaughter. Oh my God, my life's ruined. What do I do? Crap. Bury in the car and go. Meanwhile, his wallet fell out and is now in a storm drain. Well, let's get rid of that. Let's blame it all on Chris. Let's infer from the evidence, everything, it's all on him, the mastermind here. Or it was simple as meeting a Mel on Grindr. We heard about that. We knew he was on it because the detective even told you, yes, there was, in our investigation, he had been on there and he got scammed by someone for money. The person needed help. Even a friend or neighbor had talked about it too. And so he's on this app, which we heard from one of the gentlemen that it was a male app for hookups in the gay community. Say it's as simple as someone said, sure, I'll swing by and get you. I'll be on Beach Parkway. No, don't leave. I'm drunk, I'm going to bed. He's going off with friends. And then they come by, pick him up. Who knows? He has a heart condition. Something bad takes place. Well, let's blame it all on Chris. That's a simple, reasonable explanation. He left. He's half drunk. He's on all these meds. He has these heart issues. There's lots of canals around there. Who knows what happens? Truth is stranger than fiction. And the state wasn't there. They're so certain as if this is exactly what happened, yet but things don't add up. You know, their theory is not consistent. Why is that? Because their one theory is he's this mastermind that goes off radar and uses VoIPs and is so savvy technical, yet every little thing he does is on the phone. Every search he conducts, and where he goes to, and text messages he sends back and forth, like it's all on there. Like they got his phone and they checked it and examined it. And so on one hand, it's, like I said, he's so smart and savvy and technically inclined and can stay off the radar, and yet he goes to like Walmart where everybody knows they have 1,000 cameras like Target and Publix, and anywhere you go nowadays, there's a camera looking right at you. So there's no getting around that. Same with ATMs when you take money out. There's cameras, it's right there. I mean, there's no getting around that nowadays, this day and age. But yet he's such a mastermind, he can stay off the radar. Like, I mean, it went as far as, well, look, he parked a little further out this time. Is that to get out the exit real quick? Or maybe in the one shot, there wasn't anywhere else to park. And he parked farther down. Maybe you don't want to get the Jeep banged up. So, had some notes on some things, then I'll go through some of the witnesses. And I was gonna mention too, is when he was at the Airbnb and he's constant communication with the lady about what he's doing, when he's gonna leave. Hey, if you had a broom, I'd have swept up. I couldn't find one. So that kind of says, hey, there's some stuff there I'd clean up for you, but I couldn't find a way to do it. She later cleans it up, leaves him this glowing review, wonderful, stay, good things to say. But he says, I'm going for a run, and then later she sees him coming back from the run. So he's not like off radar, hiding out, pulling up to the back of the Airbnb, sneaking in the back door, going, leaving. We saw pictures of the front and back. So his actions in other places don't match like this mastermind that's like trying to stay off the radar. So maybe why an Airbnb? What can we infer as to that? Well, Barry's leaving. The thought is he's with friends. Things are fine. There's nothing to worry about. Well, why don't I go stay somewhere? Then when he comes back, he's like, well, where's Chris gone? So now he's calling me. It's kind of a relationship thing. I mean, it was only like a 2-month from Cinco de Mayo to this time. But that's kind of what it was. Well, this is his condo. I'll go stay somewhere else. So he goes to some random Airbnb in Cape Coral. We saw pictures in the driveway. And he pulls up and he goes there. And then he gets the one in Clewiston. Let's get one a little further. This one's kind of boring. And he goes out there, and then all the photos with there's a little dirt. The front wheels have kicked up a little dirt here. He was in a rural area, so he must have been doing something horrific. And later, I don't know, he came back. It was on the Saturday, and he goes in the condo, and the packages are in there. And he thinks, well, wait a minute, someone's been in here. Has Barry been back? And he's put the packages in there, and then he's down at the pool, and he mentions that later when he reports it to the police. Well, he must have came in, and they're like, well, why are you reporting them missing? And on his watch here, which they both had watches, for what it's worth.
Objection, Judge, that's not evidence.
Bruce? Sustain the objection, and counsel may continue.
Thank you. So the concern when he came back was, okay, well, maybe he came by here because now these packages that apparently have his name on them that he ordered, whether they were personal or work related, are now in the condo. So when he reports it, it's like he must have been here. Then there's the talk about the Italian dinner. And then it's, okay, well, we can't find that. It's not on his phone that he sent it. So we see that it's a VOIP, or a number we can't per se track. So now he's like the mastermind, yet they got his phone and there's nothing on there about going to some website to create some number to send some text message. Like there's just total absence of any of that. So, but he's thinking he had been by there, and so there's not really concern now. But then I talked to Miguel, and Miguel tells me, like, no, we haven't heard from him. Now he gets worried. And he calls the Lee County Sheriff, and then they talk about how long it took him to call. I mean, maybe he had to look up. You don't want to call 911, like, since it wasn't an ambulance or someone right away. So he found the non-emergency number and called it and reported it, and then an officer came out, and you saw that. And so every little action of what he does is analyzed. You know, why is he going to Walmart? Well, maybe he's going to move out. And since Barry left the Jeep, he's going to use the Jeep. Barry keeps the Jeep pristine, which if you saw pictures, yeah, it was pretty clean in there. So let's get something to protect the inside as I fill it with items I own so it doesn't scratch things up. You know, later let's buy a chemical, let's buy this new car smell. Let's keep it the way Barry would like it. Let's be respectful. Then later, again, the inference for the Ace Hardware, like, again, another store, it's going to be on camera. There's, like you said, no getting around that. Why buy a shovel? Does he know somebody out in that area and he's going to help put in a mailbox? Like nobody goes beyond and finds the answer. Supposedly he's like mysteriously off the radar or something and doing nefarious things as to innocent explanations that can be there. Let's infer the worst. But then I was going to mention the Cape Coral Ace, where things are left. Well, someone else can maybe use it. I don't need it anymore. Help somebody out with it, so let's leave it, and then somebody else can maybe get some use out of it. But if he's such the mastermind, it goes off the radar. Well, the Caloosahatchee's on the way. Why not just toss it in there, or toss it out in the woods? Like if you're really trying to get rid of something bad because you've done something wrong, why not get rid of it like there? Why go to an Ace, you know, in a city where there's cameras everywhere and surveillance and all this stuff? And then the normal routine of going to the Starbucks, because now he continues going to the Starbucks. And so I was going to bring that up. Is normal times in life, you go places, Publix, and see the cashier, or the Starbucks, and you recognize people. You don't stop and tell them your whole life story sometimes. Maybe you do, but sometimes they're busy. You don't say, well, yeah, I just got out of the hospital, I had surgery, things are horrible, my aunt died. Like, you don't tell them your real life story. You just kind of give them a little snippet and move on. Oh, he's with friends, or he's off on business, or where's he at? So you just kind of tell them something and move on, and they go back to working. Then about the tow truck, and I brought that up because you heard it's not on a rotating list. They call this one company for specific situations, I guess. And I imagine, like, you have vehicles that crash and people die. You have DUI manslaughter where people die and horrific scenes and consequences. And so you have this one tow company for specific situations that come out. And now they're taking equipment and they're hooking it up to this car, this Jeep, because I asked them, was it on dollies, so then they kind of roll it up? Or is it, no, it's hooked up to like a line, and then it's pulled up into the tow truck. So it's not in a Tyvek suit, it's not sanitized or clean. We didn't hear anything about that. So we just know it's this tow truck that goes to real serious situations and scenes, maybe deaths and things like that, and accidents and bad situations, and hooks the equipment up, and God knows where it's been and what it's touched, and pulls the Jeep up. And then the Jeep, we know, is followed and it goes to the evidence and storage. And the judge will go through the instructions with you, and you'll get a copy of them, so don't worry about that. Some of them you saw appear on the screen earlier when the state was talking. And he'll indicate what we say as the attorneys is not evidence. It's intended to assist you or arguments when you deliberate. And had a couple responses to what the state argued in their closing. The videos, they're in evidence. You can view them again if you want, but even some of the snippets you saw earlier with them walking up Del Prado, it just doesn't appear or ever look like someone in some like serious heated end of relationship argument that's being argued to you as to what really was going on. And at Cruisers, we know from the bartender Sean that was there, because we asked him about the receipt and why does it have this other name on there? Oh, because the tab was with that bartender. So, and then it's so sure, like, well, Barry had the card and he paid for it, and then now Chris has the card. How do we know Chris didn't have the card to begin with? If you get those records, which are in evidence, and you can go through them, you're going to see charges before July 19th. Winn-Dixie, you'll see others like via Apple Pay, and these all occurred before any of this, like time at Cruisers. So there's earlier charges on there. And what it was is Chris had gone to the Cinco de Mayo party, and we heard about this guy maybe raining that he had been dating, and that's how I knew the one fellow that lived there with Miguel and Tom. So he came to the party, and Chris was there even before the rainy guy came, because he came later, but Chris had already left. And then he had met, like, ooh, who's that? And he reached out and got Barry's number later, kind of moved in with him. But here in this case, the state wants you to infer Chris is this violent, evil person. You know, he goes from the simple walking up Del Prado to go back to the place to now this like homicidal person based on some little argument about, you know, I guess it's spun out of, was it an open relationship? Was he seeing other men? You know, was he concerned about that? Who he was talking to? But we're supposed to like infer like he's going to do something so horrible. Again, even that night, if you infer, we know Barry had firearms in there. We saw from the safe, the bullets, the guns, a couple long guns, a couple pistols. Those were found in the apartment. Did one of them get pulled out? Did somebody do something in defense? Did Barry have a medical episode? None of this we know. Nobody knows. You know, but the state and the government here is so certain. No, he did something horrible. We don't know what. And we want you to find him guilty. Then to talk about Miss Weber went in. Well, that was a Saturday. Went to the pool. To the point, like he done something so horrible, but then he comes back and he brings the neighbor up to the condo. Like, come on up with me. And then she sees a wallet. I mean, how do we know she didn't see Chris's wallet? We hear from the evidence Barry may have had more than one wallet. It may have been two.
Objection, Judge. That's not evidence.
Overruled this one. Just
Yeah, so we'll submit to you there's a lot of cards. You can look through the pictures of the different ones. And I would submit the evidence showed there may have had multiple wallets, but Miss Weber may have seen like Chris's, like she's just glancing, like I noticed this in the kitchen and I noticed that. And then we know from what we see on the body cam, which you can watch again, when the officer went in there, exactly how it looked. And it didn't look like Miguel had said. If you remember, Miguel and Tom, they went on the, I guess Friday. They said, oh, it was distraught, and there was stuff everywhere, and it just not the way Barry kept it. And, but that's not what we see on the body cam when the officer shows up and he's there. So it's, I don't know if it's with time, people start adding things in their mind and really believe that's what the case was or not. And with my argument, I'm just going to make it to you. I didn't create a picture of the verdict form and put on there how you should fill it out. I'll leave that to you as the jury to do. And then I had a point which I made earlier about the records. If you look at those, the records from Mitchell, you'll see the charges before the 19th. And I brought up too about the Anna Teresa place, about he had been there before already. Unless they do free consults, he may have had a card already on file, but it was unknown if that was the case. You know, so was the card really run, or was that one they already had in their system? He just wants to run that card short. Because they kept saying that he had the card, and it's not known. So again, with the party and meeting them and moving in, and this wasn't like a 10-year marriage or some like long-term serious relationship that's now falling apart. It was, you know, some guys, and you heard Chris had dated a few people, Rainey, the other guy who was the bartender at one point. Now he's dating Barry. So he can go out and date someone else. It's not like his world is over. Now, Barry was taking care of him in that you didn't hear he had a job or his own money at that point. So he was maybe trying to get his life back on track and find work. And he did tell the one neighbor like he wouldn't really have much of anything. He was kicked out, but I guess he could go to his mom's and live and find a job, and if he wants to date someone else in the future, so be it. But it's not, the world's not over as if this is like some serious long-term relationship. And again, you get the videos of them going up Del Prado, and you can see, does that look like some like crazy, you know, argument where people are away from each other and screaming and yelling, and it's that heated? No, it looks like they're just kind of walking close to each other and talking or whatnot. Then, yeah, there was, I think the state in their argument indicated, and he killed him on the way back from cruisers. And if I'm wrong on my memory of the argument, that's what we believe is heard, but that's all speculation as to what took place. And it's taking what evidence we have and trying to put together what happened or may have happened. There was a text I noticed when we were looking at the text messages and stuff they put on the screen. There was one from July 4th at 11 p.m. and it was purportedly from Barry. And if you look at it, there's no space, period, space. There's actually zero punctuation in there. And then, so the argument is, well, was this something typed? Was this the text to voice? Was this, again, that's argument. None of that's in evidence. But what it is we have this small window of time where we're looking at some messages and saying, well, that's how this person always does it and has always done it and must always do it. And so then that means this is from him, but that one's not from him. And it's again, it's just speculation. And it's trying to look at these things in the light most unfavorable to Mr. Davis. And then again, the VOIP, and I mean, they examine his phone, they find nothing on there of him going to some website to create some phone number and send some message. With the Starbucks, the card, like I mentioned before, you can see earlier charges. I already talked about, like, you don't say everything like, where's Barry at? Okay, well, let's stop. We were a cruiser, and there was argument, we were drunk, and like, you don't say all that. You're just like, well, he's out, or he's with friends, or he's doing work, like, and you go on. But his kind of pattern there, going to the Starbucks in the morning, didn't change, as if like something horrible had happened. At this point, and that was up to talking to Miguel, he thought Barry had gone and was staying with friends, and well, I'll show him and I'll go stay somewhere else, and then he'll wonder where I'm at. Then he talks to Miguel and he gets really worried because he hears, what, you haven't talked to him? He hasn't talked to you guys? You haven't heard from him? He's not with you? And then there's inferences about the phone, the broken phone. Remember I asked one of the witnesses, well, they can, if you got a bad battery, they can repair that too. So we don't know why that type of place was sought out, but we're speculating there's a phone and it's broken and we don't know. Then there's the mistake in the date of birth. Maybe he's upset, scared, worried, and he's trying to tell the officer what he knows. And the officer's kind of, well, I mean, if he was here and you saw this, he went to dinner with somebody, maybe wait. So he was like, maybe Tuesday or Wednesday. So he's just trying to go along with what's being said to him. And then there's talk about the cats, and we heard even this morning from the detective a little bit about that. Whether the scratches came from there. If anybody, use your common sense here. I mean, I got cats for what it's worth, but use your common sense and what you know of cats, and sometimes they just jump, but we never heard anyone explain what kind of like how they left, who took them, did they use a leash or harness or something, because you can't like tell them come on and like go get in the car and take them away. You got to either take hold of them or use a harness or something around them to remove them from the condo. And that's just some unanswered question. And he must be lying that he had the, cat scratch got him. That's something that could happen. He must have been in the brumble or the brush. So I was going to kind of just run through some of the witnesses we heard testify. We heard from Miguel, longtime friend of Barry, who met Chris at the Cinco de Mayo party, and then they rented an Airbnb. Like that person was so odd. Got an Airbnb, but even Miguel, they get the Airbnb for Tom's, so he can kind of set up, and Tom doesn't know about it, and surprise him, I guess. But he knew about Barry's medical situation, heart condition. He was aware, asking about some of the medicines he was taking and whatnot. And he saw, because he was talking about the phone calls, like, well, I know that's his voice. And it's like, okay, it's been 2 years now. But even way back then, you saw the guy once at the Cinco de Mayo party, and you saw him at Tom's birthday, and you're not really having a lot of talk. And you mentioned maybe at dinner. So he's only heard this guy a few times, and you might be able to say Barry, who's known a long time. That doesn't sound like Barry. But whether or not, how certain can he be who it is? And you heard from Ruth about the pole and who she would see down there. You did hear from one of the neighbors about, like, everybody would say that he didn't let anybody drive the car, and then he would be surprised to hear that neighbor in the condo drove the car. For what it's worth, it's like everyone's so certain on his behavior, like, no, he would never let anybody else drive his car. And you'd be surprised to hear, maybe if it was the airport, okay, like it's an exception or something to drive the Jeep. And she didn't see others driving it. When you hear about an Uber, they get dropped off at the cruisers. I guess they don't have to walk all the way down there, but then they decide to walk back so they can talk about it. And some of the witnesses here. We heard from Rosalie. She knew too about the heart condition. And he was supposed to come up and visit. And then what was odd was with the real personal friends, like, or the people from Illinois, is they knew like a lot of things about his life, his business, and like his life, but the whole like dating world and seeing other people, that was like a total off-limit area. We just don't talk about that. I wouldn't even ask him about that. Or, with her it came up, well, why'd your camera go off? Oh, someone's in your condo? Oh, you're dating somebody? It just seemed odd that was such a gray area that none of the friends were let to know about. But I guess Miguel, one of the firms down here, those, they did know about the, like maybe the scam, the person on Grindr he'd met or something that scammed them for money. Let's see, then we heard from Mr. Blondin. I think I got the name of the bartender wrong before. Christopher Blondin was the bartender at Cruisers. And they just sat at the bar. No one got loud. He used a car, but that was the cashier, Greg. Then there was Sean Ribbentrop, who lives with Miguel. He's a technical ward. He said they contacted through this Grindr app to get the phone number, and he didn't have it, so he had to ask someone else for it. And he was actually at Cruisers with Jeff, Miguel's other roommate. And Jeff went and spoke with Chris or Barry, one of them, at one point. And then soon after they left, and it was like Barry walked out, and then soon after Chris walks out, and then we see him on the camera. Like, it's not like a big scene or a big situation that's being made out to be. But it has to be made bigger to explain what they want you to believe took place, like what explanation the state's come up with here. You hear from Kim Zen Sultani. She talked about seeing him at the beach, meeting Chris and Barry at a condo. They went to Gasparilla Island or whatever one day, came back. They would both be up walking 4:30 in the morning, 6 to 7 miles. That was after the health scare. He lost a lot of weight. What else? And Miss Hernandez, that was a lady out with the Airbnb. She said, no, I didn't think it was odd. He was just drying out some clothes. I mean, maybe he went for a jog, his clothes got sweaty and like wet, and he hung them there, and now they're drying. No, it didn't seem odd. And then he was leaving, yeah, I saw him, and I did notice he wasn't the Tyler guy. Like, you know, again, he's some mastermind of retrieved the state account. It's his brother's account. And I heard the detective even say, yeah, I found out apparently when he investigated that and talked with his brother that his account got canceled or something, and so he was using the brother's account. Like again, that's all tracked, so it's not like it's something you're doing that's hidden. And he even messaged her about, I would have cleaned up, but I couldn't find a broom. Don't worry about it, I'll clean it up. And she did say it was a little dirtier than normal, with some debris and stuff around the couch, and then the sand in the bathroom. So whatever, if he, like I submitted before, what can we infer? Was he helping put in a mailbox with a friend? Was he helping do some other project? Who knows? Let's just infer the worst. But what it's worth. She cleaned it up and gave him a great review. Some of the other witnesses we heard from, the Starbucks lady, Ms. Sultani, she came back again. We heard from a number of witnesses more than once. And the second time Ms. Zen Sultani got up, I asked her, because she was identifying, like, I think that's Chris Davis on there. It's like, you met him the one time, and then you were at the beach, and now you're like an expert on his voice. But I said, had you ever heard him on the phone before? Because some people sound different talking on the phone, but no, I never talked to him on the phone. Then we heard from Miguel again, the detective again, and Mr. Joby. We heard from him. He was important because he took the meds to sleep. He woke up early, and he heard a plastic noise. And the big deal was made of that the light was out, but he testified, well, I saw him, and he was turning the light on. So again, he's trying to be this mastermind who's trying to like hide and be deceptive and do things under the radar, why is he turning the light on? Like, leave it off. I mean, now it's illuminated, and you know, whoever, if you're trying to hide who you are, why are you turning it on? So and my last question was like, so we fixed it, like it was off and he put it back on. And then he later said he looked like he was carrying beach chairs down there. Okay, well, put beach chairs in there, they can easily hit the sides of that Jeep and tear stuff up. So maybe it's like we are breaking up. I need to start packing stuff up and taking it away from here. So, but let's infer the worst. And again, it was kind of like, I couldn't say 100%, I didn't see his face, but I know his body, there was only 3 males, like, well, was it him or not? Like he had said before on his walks, he would see him be afar, because he would go out for walks early. And so it's like a neighbor, it's like somebody right up there that you know, like, he's like scared and went in, and again, this 2 years later, so I don't know if there's some addition to it, like this was scared, and like, if it's that serious, why didn't you call the police? Or, if it's somebody you know and have talked to before, why not step out? Like, hey, I gave you a hand, what are you doing? Got carry the beach chairs for you? Like, some of it doesn't make sense. Just what I'll submit to you. Then we heard the folks at the Brenda, this Cora, the Ace Hardware in Clewiston. She worked there. Guy came in and bought the stuff. It was on the camera. Mr. Wilson. Again, he did see the cats inside. I remember asking him about that, about the smell. Because everybody else was like, I never saw the cats, or I saw one cat on the lanai, or I didn't see any cats if they were hiding. And he was like, hell yeah, you could smell it. You know, if everybody has cats, you can smell the litter box. So such a big deal was made out of buying like the new car smell, and then like the Yankee Candle freshener things, like so maybe it was to help with that smell. And you heard from Mr. Hewitt, the gentleman that walked out back. You see on the video, like, hey, what are you doing? That's for cardboard. And I guess you can re-watch it, because he said after he thought he was walking in that the person must have left it there, but nothing really happens after he's walking in. So it must have already been left there. Like, here, I don't need it anymore, take it, somebody else can use it, or get rid of it. But again, if he's the mastermind, let's throw it out in the woods, or throw it in the Caloosahatchee, or like if there's some nefarious purpose behind it that you've done, get rid of it, not bring it back to an Ace Hardware. And then Detective Bearman again, we saw pictures of the Jeep, it had a little bit of dirt on it, but we know he'd been in a rural area. And even if you look at that Airbnb and the pictures out there in Clewiston, like, a lot of those roads are dirt. And so just, I mean, if you push the gas too hard and the wheels spin, some dirt kicks up on there, it's like, oh my God, he's killed somebody, there's dirt on here. It's everything, like the worst is assumed, and the light, the most unfavorable to the defendant. But when you look at other innocent explanations, it's, oh yeah, it really wasn't a rural area, so of course there may be some dirt on the pristine Jeep. Which, if he wanted to cover that up, I guess he could have gone by a car wash and just sprayed it down, and like nobody sees the dirt. If he's, you know, that trying to deceive and hide things. And heard from Miguel again. More new witnesses. Mr. Palmer at the gas station, he filled it up with gas. And then the detective that had gone through some trash, found the hand truck thing. If he's moving out, like you need a hand truck from the 3rd floor down, all the way down. You know, that was later, and then much was made about the safe. I mean, maybe he likes that type of safe and he wants to get his own to have. Nothing wrong with that. Then there was Dante Anderson. We heard from him yesterday morning, maybe. He was at the Ace Hardware, and he's the one that actually moved it. Like, oh, let's bring that inside instead of throwing it away, for whatever purpose. And then we heard from Officer Lilly. He's the one with the body cam, which you can watch again if you like. Heard from Ms. Weber. And you know the heart issues and the hospitalization and whatnot, but you guys remember the witnesses and what they said. I was going to go through some of the jury instructions before I'm done here. And in there, the introduction, the first one, the introduction to homicide, the judge will indicate that a killing that's excusable or was committed by the use of justifiable deadly force is lawful. So the state is so certain we know exactly what happened, and it was murder with ill will and spite and hatred, and we have no evidence of it. But you'll be instructed that justifiable homicide is lawful, excusable homicide is lawful. And then you'll get to specifically the second-degree murder, that the death was caused by the criminal act of Christopher Davis, which there's zero evidence of. And that there was this unlawful killing with a depraved mind, and then that's kind of the definition of that is given to you, that it's imminently dangerous to another and demonstrating a depraved mind if one of them is done with ill will, hatred, spite, or evil intent. And so we don't know anything like violent in history or anything of that nature. It's just, nope, let's just assume that's what happened and what took place, and he did it, and there's no other explanation. There's no evidence of it, and you're being asked to infer that's what took place. Our minds, I guess when we have a chain of events, kind of like in jury selection, when you're asked, well, you went out and it snowed, and would you believe it snowed last night even though you didn't see it snowed because you see the snow on the ground? It's kind of like if you go out in the morning and the grass is wet, and you think, did it rain? I don't think it rained. The back patio wasn't wet, but now the grass is wet. Well, okay, I guess it rained. But then you later see your neighbor's sprinklers pop on, they just installed yesterday, you didn't know about. That's why it's wet. Oh, okay. Our minds want to try to explain things, but sometimes we get it wrong. Then later you'll go into the elements of the fraudulently used the cards. Chris moved in, Barry was taking care of him. From the evidence, Chris, there was no evidence he was working at a job or had his own funds. So nothing was done fraudulently in these aspects. He was allowed to use these cards, he was given the cards, and please look at the records and you'll see the charges before the 19th that helps show evidence of the use of the cards before then. Later in the instructions, the judge will go into plead of guilty, reasonable doubt, and burden of proof. That to overcome the defendant's presumption of innocence, it's the burden on the state to prove the crime charged, the defendant committed it, and beyond a reasonable doubt. And I argue to you that the state has not proved it beyond a reasonable doubt. And with the defendant being presumed innocent, there's no reason for him to even testify. He's entered a plea of not guilty. And there'll be instructions regarding that. Also, it's the evidence introduced in this trial, and to it alone, you were to look for that proof. So you can't infer there's this other evidence or infer these other things that happened. It's only to the evidence introduced in this trial. And so when you only look at that, there's alternate explanations exactly what could have happened and what really happened. In a reasonable doubt, the judge will instruct you. Reasonable doubt as to the guilt of the defendant may arise from the evidence, conflicts of the evidence, or the lack of evidence. I'd argue it's the lack of evidence in this case. The big glaring holes or periods that the state says, no, this is exactly what happened. This is what must have happened because next, this is what happened. And there's multiple other explanations for it. If you have a reasonable doubt, you should find the defendant not guilty. That's exactly what I'm asking you to do. And with the instructions, you'll be asked to go back, pick a foreperson, which is someone who kind of leads the jury selection meeting, and then you go through the instructions and any evidence you'd like to see, and go through the verdict form. But I submit, that's why I asked you to wait. Wait till you make any fixed opinion, use your common sense, and at the end of this, I think you'll find the state has not proven the case beyond a reasonable doubt, and the verdict should be not guilty, but also the defendant's innocent. Let the guy go. Thank you.
Christmas Eve, Becky Weber received a gift from a man she'd never met. He'd gotten her a bottle of her favorite tequila. She'd never met him, but somehow he knew exactly what she wanted and what she drank. He was kind, he was thoughtful, he was considerate. That was very Schmalbach. On the 5th of May, 2023, Christopher Davis met a man. Within weeks, he moved in with him. 2 months later, that man went missing. He began driving his Jeep, using his credit cards, trying to access his safe, changing out the locks on his condominium, and getting photons. That was Christopher Davis. Now, ladies and gentlemen, when circumstantial evidence multiplies and interconnects, you see the truth and you know what happened. It offends common sense when the truth is attempted to be explained away with nonsense. I told you, we don't know the whereabouts of the body of Mr. Barry Schmalbach, because he made sure of that. We do know that he didn't leave. He was killed, he was disposed of, and his remains remain hidden from his clients, his friends, and his family. If we've learned anything during the course of this trial, ladies and gentlemen, it's that Barry Schmalbach would never, ever have left without letting anyone know where he was going or when he was going to return. That's not going to happen. It didn't happen. There's no way. He valued his relationships. And those relationships were returned in kind to him. He's had relationships for over 40 some odd years. He's kept in contact with these individuals. He's made friends. He's brought them tequila to people he didn't even know. They meant something to him, and he meant something to them. Ladies and gentlemen, Barry Schmalbach is dead. You should have absolutely no doubt about that in your mind. Because, ladies and gentlemen, this case didn't need a body. It never did. What it did need, however, ladies and gentlemen, is it needed a body of evidence. And that's exactly what we've displayed for you over the past 3 days. Take a look at it. Ladies and gentlemen, we're not trying to offend your common sense. Your common sense, if you remember, was 10. all the way through, each and every single one of you. So my common sense is 10. Well, what does your common sense tell you? Well, we're not asking you to infer anything. We're asking you to put the pieces together. What do we know? We know that there was an argument. We know that it was heated. We know that Mr. Schmalbach left. We know that he chased after him. We know that Mr. Schmalbach was not very happy with Mr. Davis. We know that there were sounds that came from that condominium. We know that there was a whimper. We know that there was a no-no. Well, what else do we know? Shortly thereafter, he's going to Walmart. He's getting a tarp. He's getting duct tape. He's driving the victim's Jeep. Who drives Barry's Jeep? Except Barry. Somehow, now he's driving the Jeep. But defense counsel would have you believe, gee, on Wednesday, July 19th, shortly after getting back from cruisers, despite him telling you that, oh, I was drinking, I fell asleep, and I don't know, when I woke up, he was gone. Really? We know that's not true. We know that he went to Walmart, but defense counsel would have himself argue that, oh, he's just going to go ahead and move out. He's going to go ahead and put this tarp in the back of this Jeep because, you know what? He's so respectful. Oh, he's respectful, all right. What he did was he wrapped up Mr. Schmalbach in that tarp, used all the duct tape up, right? Common sense, right? What do we know? He's dragging him out of that condo. Why? Because Brian Job sees it. He looks out. Who's this? Oh. Kind of closes the door a little bit and does recognize who? Him. He recognizes him. Do the math, ladies and gentlemen. Common sense, right? It's not Brian Job. It's not Christopher Davis, because Christopher Davis is the one pulling this bag. Who's in the bag? What's in the bag? Heavy plastic, and he's dragging. The evidence that you heard, ladies and gentlemen, was that the last call and last text that came from Barry Schmalbach's phone, outgoing, not ingoing, out, was on the 19th of July, 2023. That phone, ladies and gentlemen, is important to Mr. Schmalbach. He's got it in his top pocket. Just in a picture. He went down to the pool area with it. That was his work. That was his business. That's how he kept in contact with people. You texted him, he texted you right back. What else do we know? He always had his iWatch on him. But what's interesting is ultimately that little iWatch winds up in the little office area in the condo, right? And we heard from Becky Weber, who says, yeah, we can find it because he left his iWatch behind. And that's even what he told the officer when he was trying to file his missing persons report, and he lied about his date of birth. I mean, what else did he lie about? Begs the question. I would submit to you the rest of it. You've seen in numerous videos with the iWatch. Barry always wore his iWatch. Why? Because he had a little health scare. He lost a body in weight, according to Tom Wilson, if you remember, right? He was doing better. He was walking 5-6 miles a day. He was that health conscious. As soon as he learned about the abilities of this iWatch from who? Becky Weber? Boom. He got himself an iWatch. Never took it off. Was always seen with it. He was even in the pool with that thing, posing with pictures with his friends, right? That iWatch was always on Barry. But guess what? Now all of a sudden it's on his wrist. Begs the question, how did it get there? Common sense. Gee, who's in the tarp? Who's saying no, no? Who's whimpering? Who's not sending out any more texts or calls from that phone? Mr. Schmalbach. Then all of a sudden, guess what? Now we've got Mr. Davis, right, running around to all these different businesses, whether it be Publix or Target or Lowe's or Home Depot or PNC Bank or Seacoast Bank, Walmart. You got to see how these cards work, right? The cards that work in his wallet. Cards that didn't, there's his wallet. Calls his PNC Bank, right? Calls them up. Can't even tell him his phone number. It takes him 10 seconds to tell him what the phone number is that's associated with the account. Come on. Mr. Schmalbach has had that number for how many years? Even Leon Giacchetti said, he's had that number since I remember. Christine Gleason, oh man, she couldn't even tell you how long he's had because it's been that long. But it's taking the person on that call 10 seconds. Oh man, I can't remember my phone number. Are you kidding me? Common sense. Defense counsel wants to talk about light bulbs, right? Oh, well, there's some nefarious reason for him to go on ahead and, just turn off the light bulb. There must be some kind of, maybe he was just trying to turn it on and be helpful. Ladies and gentlemen, the reason why you turn off a light bulb is because guess what? When you're trying to move a dead body out of a condo and trying to get it into the back of a Jeep, you don't want anyone to see you. That's why you're turning it down. But when you turn it back on, guess what? There's nothing to see here. Oh, I got bins. It's just got some stuff in it. Oh, I might have some beach chairs. What? That's when you turn the light on because guess what? There's nothing going on. I can explain that away. But I tell you what, if you turn that light on and you're dragging a body out of a condo, you got a lot of explaining to do. That's why his fingerprints are on that light bulb. Christopher Davis also managed to go ahead and relay a bunch of various stories to a lot of different individuals with regards to what happened with Mr. Schmalbach. Not only is he telling stories to the lady at the PNC Bank as far as who he was, he's talking to Miguel, telling him, oh, I thought I was with you. He's telling law enforcement, oh, he's at Italian dinner. Oh, he's telling the lady at Starbucks, oh, he's working. And then he's telling the lady at Starbucks, oh, now it must be a hate crime. You can't even keep the story straight, is it? But that's what have you argue, oh, it could have been a DUI manslaughter, someone came along, just hit them and left them, and the one problem with that is there's no body. If there's a DUI manslaughter, there'd be a body, right? So the first thing that Mr. Davis does after he gets rid of
objection to the state's demonstrative. As you,
Can
once
I
I,
see the aid? I'm sorry, can you just turn it so I can see it?
once I realized it was a jail booking photo, not a photo in evidence.
No, I can see it, I'm sorry.
I'm not asking any motions. On top of that, I'm just asking maybe the state removes it at this time instead of leaving it up there.
How do you know that that's a jail photo?
I've done this so long.
What?
It's a jail uniform, I believe. He's looking up to see if it's the picture when he was booked into the jail.
Okay. You want to respond?
Very well, they could be, Judge, but if you look at the photograph, this looks merely like it just depicts Mr. Davis's face, and it looks like a polo shirt.
And this is a copy of what's on the demonstrative aid.
That is correct, Judge.
I'll just make that part of the court record. Just to describe it on the record, it's a photo with text blocks surrounding it, and the photo itself appears to be a photo of the defendant. There's a blue background, and he appears to be wearing some type of a red shirt that really has, looks like a collar and seams going down the shoulder. What, if anything, about that indicates that it's a jail photo?
I can show you the jail photo.
But I mean, what about the picture would indicate to the jury that it's a jail photo?
I guess any of the jurors happen to know red jumpsuits.
There's nothing indicative of that particular photograph that is indicative of a red jumpsuit. It looks merely at a polo shirt, Judge.
Anything else?
No,
So you're just asking them to take down the demonstrative aid?
yeah, just because it's a picture, not in evidence.
It's merely demonstrative aid. It's going to be my argument to the jury.
Okay.
You don't have another photo close-up face like that, I guess?
Put on top of it.
Yeah, well, all right. All right. I mean, I reviewed the exhibit, and it's as I described it. There's nothing that indicates on the photo itself that it's a jail photo. Someone who might be, have a close eye and very experienced in what jail photos look like might be able to detect that, but honestly, looking at it for the first time today, I cannot tell you if that is a jail uniform or if that's a med polo. I honestly don't know. So in terms of, I guess, any objection to it at this point, I would overrule the objection and we'll let you continue. Can we just take a short 5-minute break before we bring that in?
Yes, sir, thank you.
All right. Recess for 5 minutes. bring the jury back in. Defense ready?
Yes.
Okay, let's bring it back. Out, we can inquire, or we can just put it back under C. Is that okay? Just put it back under C?
Sure.
Okay, no need to inquire or anything?
No.
Okay, just put it back under C.
So as I was saying, ladies and gentlemen, where we left off, the next thing we know is that Mr. Davis goes ahead and begins seeking out Airbnbs. What is he trying to do? He's trying to go ahead and meet up with other individuals. He's the one who's on Grindr. He's the one who's trying to meet up with individuals. But yet he wants to go ahead and tell that story to the officer, talk about, oh, well, he's seen other people, we're in this relationship, and he's trying to put it all on Mr. Schmalbach. We know that's not true. But then what happens is what? He goes out to Clewiston, right? He goes all the way out to an hour, hour and a half out of the way to do what? To do some digging? To do some gardening? To go ahead and dig a hole, a foxhole? No. We know why he's out in Clewiston. We know why he's going ahead and getting that pickaxe. We know why and how he's got a shovel, right? He only stays out there for a day. What does he have with him? I watch. But he's trying to cover his tracks. The defense counsel wants to say, oh, he's this mastermind and you shouldn't go that far. Well, think about what he's doing, ladies and gentlemen. He's gone ahead and just gone ahead and killed somebody, wrapped this person up in a tarp, gotten duct tape, putting him into the back of a Jeep, taken him somewhere, turned out lights so he cannot be seen, gone ahead and began using all of his cards, because guess what? His little house of cards is falling down around him. Think about it for a second. He met Barry Schmalbach at a Cinco de Mayo party. He's the one who saw it out, Mr. Schmalbach. Within a couple weeks, he was moved in with him. But remember what Ms. Stanford also told you? Oh, he'd gone ahead and lined up a consultation already at Anna Therese. Oh, the card on file at Anna Therese. Remember what Ms. Stanford told you? She said that when he had that appointment on the 24th, that's when he gave the card, that's when he paid that $1,400, right? But what I'm trying to tell you, ladies and gentlemen, is he's the one who sought out Mr. Schmalbach. He's the one who's trying to take advantage of Mr. Schmalbach. We don't have to establish motive in the case. We have to tell you the who, what, when, where, why, right? It's the why that everybody wants. Sometimes we can't get it. But in this case, it screams. The motive, ladies and gentlemen, is because he was having problems with Mr. Schmalbach. How do we know? Because Becky Weber told you that. He was afraid of a breakup. He was afraid of getting kicked out. He had nowhere to go. He had no money. That's what he told Miss Becky Weber. What did she say? Well, I can help you out with that. Let's go back, and there's his iPhone, right? Or his iWatch, excuse me. What else was there? Well, 3 things that Mr. Schmalbach would not go out to an Italian dinner without. His iWatch, his iPhone, his wallet. But just so happens that, guess what? His iWatch is there and his wallet's there. Weber saw it. Now it was on the 22nd. And that's when he told law enforcement, and law enforcement asked him specifically in the body-worn camera, he should have his phone on. His response was yes. But we know that's not true. Because why? Because not only is this case in the garbage, but we also heard that PNC Bank call, right? That happened on the 20th. The very next day after Mr. Schmalbach is deceased. That phone call, if you remember it and if you listen to it, she specifically said, I have to send you a verification code, right? And he says, I can't receive texts. She goes, okay, well, we can send it to you over a voice call. And what did she tell him next? Well, voice call will be sent to what? The number that's associated with the account, which was what? It's that 708 number, right? 341-0721. Barry Schmalbach's number, the one he's had for God knows how many years, right? And that's how he was able to relay that number back to the customer service rep. He also had the phone. He had not only disposed of and gotten rid of Mr. Schmalbach, but he had everything. His iPhone, his iWatch, his wallet, his cards. I'm not going to belabor the texts. You've heard those. They're in State's Exhibit number 40 and 40A. Look at them. Space, punctuation, space. Okay. He's so respectful, right, ladies and gentlemen? He wants to go ahead and put a tarp in the back of his Jeep so that way it doesn't get dirty. He goes so far as to go to Walmart and gets a cleaner. Really? He wants to make sure it smells fresh. That's what we're doing? No, that's not what we're doing. Because what do we know about that Jeep? That Jeep is clean. That's his business. That's his representation. If he had his clothes in there, you know, he was dirty, he's sweaty that day, he'd have a change of clothes. He worked out of that Jeep. That Jeep was him. He was that Jeep. That Jeep was always clean, immaculate. Clean inside, clean outside. He would always make sure that thing was washed. That thing was clean. That thing was dirty. How do we know? Well, if you listen to Casey Buckner Brager, right? That was our crime scene tech from the Cape Coral Police Department. She told you about the photographs of the things that she found in the back of that trunk. She found that cleaner in the back of that trunk. But what else did she find? Remember those pictures of the back in the corners there? Where it had those little drips and drops and it's really hard to see, but it's there. There's no way that Mr. Schmalbach would have left all those little drips and all those drops. How do we know? Because you've heard from everybody. Ms. Monaco, Ms. Leon Giacchetti, you heard from Miguel, you've heard from Mr. Tom Wilson, you've heard from just about all of his friends that have indicated this is who Barry Schmalbach was. He was immaculate. This is how he kept his condo. This is how he kept his Jeep. This is how he kept himself. This is how he responded. And those people were so concerned that they wanted to make sure where Mr. Schmalbach was. So what did they do? They reach out to him. Mr. Blanco told you, I had a text conversation with Mr. Davis. Should I file a missing persons report? Yes. That was Mr. Blanco's response. Right? But what do we know? Well, when that conversation was done, it took over an hour for him to contact the Cape Coral Police Department to file a missing persons report. Really? Well, that's the only reason why he goes to the Ace Hardware, because guess what? In that period of time, rather than going ahead and contacting Cape Coral Police Department, he decides to drive all the way to Ace Hardware to get rid of that pickaxe and that shovel that he bought just the day before. Why? Well, if you throw it in a dumpster at the place that you bought it, or a place that's very similar to the place that you bought it, no one would think twice about it, because guess what? That's where they would throw their stuff, right? That would make sense. He thought it through at least. So then, law enforcement gets there. He gives them the story. He's in the mid stages of worry, right? Come on. Come on. Law enforcement ultimately winds up leaving. He then goes ahead the next day, manages to go to Home Depot, gets a safe, right? What do we know about the safe? Oh, the defense counsel would argue, well, yeah, you might like the safe. He might want a safe. Really? A guy with no job, no place to go, afraid of being broken up with, now he's going to get himself a safe? Really? Safes are heavy, ladies and gentlemen. It's a lot of work. It's at that point in time, if you remember, that after he gets done telling Miss Weber about where Barry is, and she tells him, hey, the last ping on this thing is, try to ping it, and it's behind the building somewhere. You don't know where it is. Got rid of it. But it wasn't not Barry. Barry's not there. But she did see definitively a wallet. And that wallet was one and the same that Barry always carried with him. It was one and the same that he always had at the pool. It was one and the same that was in the condo at the time when Miss Weber was there. She recognized it. She told you that. What's interesting about it is that wallet doesn't get found until 6 days later on the 28th by some tree fertilizer guy. Really? Why is that? It was in his control, ladies and gentlemen. He had the wallet. And the reason why we took you through this timeline from July 19th all the way to the 31st was because we wanted to make sure that you understood everything that was happening on each and every single one of these days and what he was doing. Truth, ladies and gentlemen, is not stranger than fiction. The truth is what it is. And when you try to go ahead and explain it away with nonsense, it offends common sense. Because, ladies and gentlemen, on the 31st of July of 2023, 2 cadaver dogs came down. 2 cadaver dogs were in the Cape Coral Police Department's parking lot. 2 cadaver dogs gave alerts, involuntary responses to Barry's Jeep. 2 cadaver dogs gave final responses to Barry's Jeep. You remember Dina Hutchins? What did she tell you? She said her dog, Indy, right? Wheel well to wheel well, barked at the back of that Jeep. Independent, while on leash. What did Brittany Layton tell you? Her dog, Fi, was off leash. What vehicle did it give a final alert and a final response to? Barry's Jeep. So, ladies and gentlemen, look, all those things by themselves, okay, they might not mean anything. But it's when you take all that circumstantial evidence and you put it together, okay, it means something. And when you add it all together, ladies and gentlemen, there is no doubt, much less reasonable in this particular case. Because, ladies and gentlemen, maybe it's time that we start trying to outsmart the truth. And we let the truth have its day. Because, you know what? You might be able to go ahead and kill somebody, get rid of the body, clean up the scene, and tell various stories to, friends as to whereabouts. But, ladies and gentlemen, you can't hide from the truth. I'm asking that you find Mr. Christopher Davis guilty. I'm asking that you find him guilty of second murder because of what he did to Mr. Schmalbach. I'm asking that you find him guilty for tampering with evidence. Because when you got rid of that pickaxe, when you got rid of that shovel, and tried to get rid of that wallet with all of Barry Schmalbach's information, that's tampering with evidence. Because he knew that investigation was going to happen at the start. Because that's what Miguel said, and that's what law enforcement did. And it was after that that all that began to disappear. And he was trying to make sure. And as for the fraudulent use of personal identification information of the deceased individual, you've got all the videos, you've got all the documents, you've got all the records. Take a look at it. It's all there. And after you've seen everything, you should find him guilty. Thank you.
jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Statement of charges. Christopher Davis, the defendant in this case, has been accused of the crimes of second-degree murder, tampering with physical evidence, and 8 counts of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Introduction to homicide. In this case, Christopher Davis is accused of second-degree murder. Second-degree murder includes a lesser crime of manslaughter, both of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Barry Schmalbach was killed by Christopher Davis, you will then consider the circumstances surrounding the killing in deciding if the killing was second-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1. When the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is an object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. I now instruct you on the circumstances that must be proved before Christopher Davis may be found guilty of second-degree murder or any lesser included crime. Count 1, second-degree murder. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1. Barry Schmalbach is dead. 2. The death was caused by the criminal act of Christopher Davis. 3. There was an unlawful killing of Barry Schmalbach by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3. Is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. When there are lesser included crimes or attempts. Considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of second-degree murder is manslaughter. Count 1, lesser included manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1. Barry Schmalbach is dead. 2. Christopher Davis intentionally committed an act or acts that caused the death of Barry Schmalbach. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Count 2, tampering with physical evidence. To prove the crime of tampering with physical evidence, the state must prove the following 2 elements beyond a reasonable doubt. 1. Christopher Davis knew that an investigation by a duly constituted prosecuting authority or law enforcement agency of this state was pending or about to be instituted. 2. Christopher Davis altered, destroyed, concealed, or removed any record, document, or other item with the purpose to impair its verity or availability in the investigation or proceeding. Count 3. Fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, target. To prove the crime of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, the state must prove the following 2 elements beyond a reasonable doubt. 1. Christopher Davis willfully and fraudulently used or possessed with intent to fraudulently use personal identification information concerning Barry Schmalbach. 2. At the time, Barry Schmalbach was a deceased individual. Willfully means intentionally, knowingly, and purposely. Fraudulently means purposely or intentionally suppressing the truth or perpetrating a deception, or both. Individual means a single human being and does not mean a firm, association of individuals, corporation, partnership, joint venture, sole proprietorship, or any other entity. Personal identification information means any name or number that may be used alone or in conjunction with any other information to identify a specific person, including any name, postal or electronic mail address, telephone number, social security number, date of birth, mother's maiden name, official state or United States issued driver's license or identification number, alien registration number, government passport number, employer or taxpayer's identification number, Medicaid or food stamp account number, bank account number, credit or debit card number, or personal identification number or code assigned to the holder of a debit card by the issuer to permit authorized use of such a card. Unique biometric data such as a fingerprint, voice print, retina or iris image, or other unique physical representation, unique electronic identification number, address, or routing code, medical record, telecommunication identifying information, or access device, or other number or information that can be used to access a person's financial resources. To prove Christopher Davis possessed personal identification information, the state must prove beyond a reasonable doubt that he, A, knew the existence of the personal identification information, and B, intentionally exercised control over that personal identification information. Control can be exercised over personal identification information whether the information is carried on a person, near a person, or in a completely separate location. Mere proximity to the personal identification information does not establish that the person intentionally exercised control over the personal identification information in the absence of additional evidence. Control can be established by proof that Christopher Davis had direct personal power to control the personal identification information or the present ability to direct its control by another. Count 4, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, publics. To prove the crime of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, the state must prove the following 2 elements beyond a reasonable doubt. 1, Christopher Davis willfully and fraudulently used or possessed with intent to fraudulently use personal identification information concerning Barry Schmalbach. 2, at the time, Barry Schmalbach was a deceased individual. Willfully means intentionally, knowingly, and purposely. Fraudulently means purposely or intentionally suppressing the truth or perpetrating a deception, or both. Individual means a single human being and does not mean a firm, association of individuals, corporation, partnership, joint venture, sole proprietorship, or any other entity. Personal identification information means any name or number that may be used alone or in conjunction with any other information to identify a specific person, including any name, postal or electronic mail address, telephone number, social security number, date of birth, mother's maiden name, official state or United States issued driver's license or identification number, alien registration number, government passport number, employer or taxpayer's identification number, Medicaid or food stamp account number, bank account number, credit or debit card number, or personal identification number or code assigned to the holder of a debit card by the issuer to permit authorized use of such card. Unique biometric data such as a fingerprint, voice print, retina, or iris image, or other unique physical representation, unique electronic identification number, address, or routing code, medical record, telecommunication identifying information or access device, or other number or information that can be used to access a person's financial resources. To prove the crime, to prove Christopher Davis possessed personal identification information, the state must prove beyond a reasonable doubt that he, A, knew the existence of the personal identification information, and B, intentionally exercised control over that personal identification information. Control can be exercised over personal identification information whether the information is carried on a person, near a person, or in a completely separate location. Mere proximity to the personal identification information does not establish that the person intentionally exercised control over the personal identification information in the absence of additional evidence. Control can be established by proof that Christopher Davis had direct personal power to control the personal identification information or the present ability to direct its control by another. Count 5. Fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, PNC Bank. To prove the crime of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, the state must prove the following two elements beyond a reasonable doubt. 1. Christopher Davis willfully and fraudulently used or possessed with intent to fraudulently use personal identification information concerning Barry Schmalbach. 2. At the time, Barry Schmalbach was a deceased individual. Willfully means intentionally, knowingly, and purposely. Fraudulently means purposely or intentionally suppressing the truth or perpetrating a deception or both. Individual means a single human being and does not mean a firm, association of individuals, corporation, partnership, joint venture, sole proprietorship, or any other entity. Personal identification information means any name or number that may be used alone or in conjunction with any other information to identify a specific person, including any name, postal or electronic mail address, telephone number, social security number, date of birth, mother's maiden name, official state or United States issued driver's license or identification number, alien registration number, government passport number, employer or taxpayer's identification number, Medicaid or food stamp account number, bank account number, credit or debit card number, or personal identification number or code assigned to the holder of a debit card by the issuer to permit authorized use of such card. Unique biometric data such as fingerprint, voice print, retina, or iris image, or other unique physical representation. Unique electronic identification number, address, or routing code, medical record, telecommunication identifying information or access device, or other number or information that can be used to access a person's financial resources. To prove Christopher Davis possessed personal identification information, the state must prove beyond a reasonable doubt that he, A, knew the existence of the personal identification information, and B, intentionally exercised control over that personal identification information. Control can be exercised over personal identification information whether the information is carried on a person, near a person, or in a completely separate location. Mere proximity to the personal identification information does not establish that the person intentionally exercised control over the personal identification information in the absence of additional evidence. Control can be established by proof that Christopher Davis had direct personal power to control the personal identification information or the present ability to direct its control by another. Count 6. Fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Starbucks. To prove the crime of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, the state must prove the following two elements beyond a reasonable doubt. 1. Christopher Davis willfully and fraudulently used or possessed with intent to fraudulently use personal identification information concerning Barry Schmalbach. 2. At the time, Barry Schmalbach was a deceased individual. Willfully means intentionally, knowingly, and purposely. Fraudulently means purposely or intentionally suppressing the truth or perpetrating a deception, or both. Individual means a single human being. It does not mean a firm, association of individuals, corporation, partnership, joint venture, sole proprietorship, or any other entity. Personal identification information means any name or number that may be used alone or in conjunction with any other information. To identify a specific person, including any name, postal or electronic mail address, telephone number, social security number, date of birth, mother's maiden name, official state or United States issued driver's license or identification number, alien registration number, government passport number, employer or taxpayer's identification number, Medicaid or food stamp account number, bank account number, credit or debit card number, or personal identification number or code assigned to the holder of a debit card by the issuer to permit authorized use of such card. Unique biometric data such as fingerprint, voice print, retina, or iris image, or other unique physical representation. Unique electronic identification number, address, or routing code, medical record, telecommunication identifying information or access device, or other number or information that can be used to access a person's financial resources. To prove Christopher Davis possessed personal identification information, the state must prove beyond a reasonable doubt that he, A, knew of the existence of the personal identification information, and B, intentionally exercised control over that personal identification information. Control can be exercised over personal identification information, whether the information is carried on a person, near a person, or in a completely separate location. Mere proximity to the personal identification information does not establish that a person intentionally exercised control over the personal identification information in the absence of additional evidence. Control can be established by proof that Christopher Davis had direct personal power to control the code of personal identification information or the present ability to direct its control by another. Count 7. Fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Walmart. To prove the crime of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, the state must prove the following two elements beyond a reasonable doubt. 1. Christopher Davis willfully and fraudulently used or possessed with intent to fraudulently use personal identification information concerning Barry Schmalbach. 2. At the time, Barry Schmalbach was a deceased individual. Willfully means intentionally, knowingly, and purposely. Fraudulently means purposely or intentionally suppressing the truth or perpetrating a deception, or both. Individual means a single human being and does not mean a firm, association of individuals, corporation, partnership, joint venture, sole proprietorship, or any other entity. Personal identification information means any name or number that may be used alone or in conjunction with any other information to identify a specific person, including any name, postal or electronic mail address, telephone number, social security number, date of birth, mother's maiden name, official state or United States issued driver's license or identification number, alien registration number, government passport number, employer or taxpayer's identification number, Medicaid or food stamp account number, bank account number, credit or debit card number, or personal identification number, or code assigned to the holder of a debit card by the issuer to permit authorized use of such card. Unique biometric data such as fingerprint, voice print, retina or iris image, or other unique physical representation, unique electronic identification number, address, or routing code, medical record, telecommunication, identifying information or access device, or other number or information that can be used to access a person's financial resources. To prove Christopher Davis possessed personal identification information, the state must prove beyond a reasonable doubt that he, A, knew of the existence of the personal identification information, and B, intentionally exercised control over that personal identification information. Control can be exercised over personal identification information, whether the information is carried on a person, near a person, or in a completely separate location. Mere proximity to the personal identification information does not establish that the person intentionally exercised control over the personal identification information in the absence of additional evidence. Control can be established by proof that Christopher Davis had direct personal power to control the personal identification information or the present ability to direct its control by another. Count 8. Fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Seacoast Bank. To prove the crime of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, the state must prove the following two elements beyond a reasonable doubt. 1. Christopher Davis willfully and fraudulently used or possessed with intent to fraudulently use personal identification information concerning Barry Schmalbach. 2. At the time, Barry Schmalbach was a deceased individual. Willfully means intentionally, knowingly, and purposely. Fraudulently means purposely or intentionally suppressing the truth or perpetrating a deception or both. Individual means a single human being. It does not mean a firm, association of individuals, corporation, partnership, joint venture, sole proprietorship, or any other entity. Personal identification information means any name or number that may be used alone or in conjunction with any other information to identify a specific person, including any name, postal or electronic mail address, telephone number, social security number, date of birth, mother's maiden name, official state or United States issued driver's license or identification number, alien registration number, government passport number, employer or taxpayer's identification number, Medicaid or food stamp account number, bank account number, credit or debit card number, or personal identification number or code assigned to the holder of a debit card by the issuer to permit authorized use of such card. Unique biometric data such as fingerprint, voice print, retina, or iris image, or other unique physical representation, unique electronic identification number, address, or routing code, medical record, telecommunications identifying information or access device, or other number or information that can be used to access a person's financial resources. To prove Christopher Davis possessed personal identification information, the state must prove beyond a reasonable doubt that he A. knew of the existence of the personal identification information, and B. intentionally exercised control over that personal identification information. Control can be exercised over personal identification information whether the information is carried on a person, near a person, or in a completely separate location. Mere proximity to the personal identification information does not establish that the person intentionally exercised control over the personal identification information in the absence of additional evidence. Control can be established by proof that Christopher Davis had a direct personal power to control the personal identification information or the present ability to direct its control by another. Count 9. Fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Home Depot. To prove the crime of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, the state must prove the following two elements beyond a reasonable doubt. 1. Christopher Davis willfully and fraudulently used or possessed with intent to fraudulently use personal identification information concerning Barry Schmalbach. 2. At the time, Barry Schmalbach was a deceased individual. Willfully means intentionally, knowingly, and purposely. Fraudulently means purposely or intentionally suppressing the truth or perpetrating a deception or both. Individual means a single human being. It does not mean a firm, association of individuals, corporation, partnership, joint venture, sole proprietorship, or any other entity. Personal identification information means any name or number that may be used alone or in conjunction with any other information to identify a specific person, including any name, postal or electronic mail address, telephone number, social security number, date of birth, mother's maiden name, official state or United States issued driver's license or identification number, alien registration number, government passport number, employer or taxpayer's identification number, Medicaid or food stamp account number, bank account number, credit or debit card number, or personal identification number, or code assigned to the holder of a debit card by the issuer to permit authorized use of such card. unique biometric data such as fingerprint, voice print, retina, or iris image, or other unique physical representation, unique electronic identification number, address, or routing code, medical record, telecommunication identifying information or access device, or other number or information that can be used to access a person's financial resources. To prove Christopher Davis possessed personal identification information, the state must prove beyond a reasonable doubt that he, A, knew of the existence of the personal identification information, and B, intentionally exercised control over that personal identification information. Control can be exercised over personal identification information whether the information is carried on a person, near a person, or in a completely separate location. Mere proximity to the personal identification information does not establish that the person intentionally exercised control over the personal identification information in the absence of additional evidence. Control can be established by proof that Christopher Davis had direct personal power to control the personal identification information or the present ability to direct its control by another. Count 10, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, and Therese Aesthetic Medicine. To prove the crime of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, the state must prove the following two elements beyond a reasonable doubt. 1, Christopher Davis willfully and fraudulently used or possessed with intent to fraudulently use personal identification information concerning Barry Schmalbach. 2, at the time Barry Schmalbach was a deceased individual. Willfully means intentionally, knowingly, and purposely. Fraudulently means purposely or intentionally suppressing the truth or perpetrating a deception, or both. Individual means a single human being. It does not mean a firm, association of individuals, corporation, partnership, joint venture, sole proprietorship, or any other entity. Personal identification information means any name or number that may be used alone or in conjunction with any other information to identify a specific person, including any name, postal or electronic mail address, telephone number, social security number, date of birth, mother's maiden name, official state or United States issued driver's license or identification number, alien registration number, government passport number, employer or taxpayer's identification number, Medicaid or food stamp account number, bank account number, credit or debit card number, or personal identification number or code assigned to the holder of a debit card by the issuer to permit authorized use of such card. Unique biometric data such as fingerprint, voice print, retina, or iris image, or other unique physical representation, unique electronic identification number, address, or routing code, medical record, telecommunication identifying information or access device, or other number or information that can be used to access a person's financial resources. To prove Christopher Davis possessed personal identification information, the state must prove beyond a reasonable doubt that he, A, knew of the existence of the personal identification information, and B, intentionally exercised control over that personal identification information. Control can be exercised over personal identification information, whether the information is carried on a person, near a person, or in a completely separate location. Mere proximity to the personal identification information does not establish that the person intentionally exercised control over the personal identification information in the absence of additional evidence. Control can be established by proof that Christopher Davis had direct personal power to control the personal identification information or the present ability to direct its control by another. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant not testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Defendant's statements. A statement claimed to have been made by the defendant outside the court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude that the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous, that is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged, or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. So, these are the verdict forms, and I'm just going to read them to you. In the Circuit Court of the 20th Judicial Circuit and in Fort Lee County, Florida, criminal action, State of Florida versus Christopher Davis, case number 24 CF 000083. Verdict. We, the jury, find as follows as to count 1 of the charge. Check only 1 as to each count. Count 1, second-degree murder. A, the defendant is guilty of second-degree murder. B, the defendant is guilty of manslaughter. C, the defendant is not guilty. Count 2, tampering with physical evidence. A, the defendant is guilty of tampering with physical evidence. B, the defendant is not guilty. Count 3, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, target. A, the defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. B, the defendant is not guilty. Count 4, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, publics. A, the defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. B, the defendant is not guilty. Count 5, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, PNC Bank. A, the defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. B, the defendant is not guilty. Count 6, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Starbucks. A, the defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. B, the defendant is not guilty. Count 7, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Walmart. A, the defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. B, the defendant is not guilty. Count 8, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Seacoast Bank. A, the defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. B, the defendant is not guilty. Count 9, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Home Depot. A, the defendant is guilty of fraudulently use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. B, the defendant is not guilty. Count 10, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Ann Therese Aesthetic Medicine. A, the defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. B, the defendant is not guilty. So say we all. A place for the date, for the foreperson to sign their name, and the foreperson to print their name. Single defendant, multiple counts. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. Submitting case to jury. In just a few moments, you will be taken to the jury room by the court deputy or bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy or bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy or bailiff while you deliberate. If you need to communicate with me, send a note through the court deputy or bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Most of these exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see an exhibit not sent back into the jury room, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. With that, you may take your notepads. If you have cell phones in here, leave them here. If they're back in the jury room, the bailiff will collect them and bring them out here. Also, smartwatches, any type of electronic communication has to stay here. And everybody except juror 440 and juror 394 may retire to the jury room, begin their deliberations. Juror 440 and 394 are the alternates. We don't tell people that they're the alternates because we want everybody to pay equal attention. Any objections to the instructions as read?
No, Your Honor.
All right. Everybody to pay equal attention. Had someone become ill or have an emergency or something like that, then you would get back to deliberating. So you are at will to stick around. You can talk with anybody you want. Talk about your service, but also cannot talk about the service. So if you, and it's not uncommon that people will want to talk to you about your jury service or your critiques from the attorneys or things like that, or you critiquing the attorneys. Sometimes they request that. Again, that's not uncommon, but you also have an absolute right to say, I don't want to talk about it, and tell them that. If somebody persists in trying to get you to talk about it, let a bailiff know and I'll take care of it. Do you have any other belongings back in the jury? Yes. Okay, so when he comes back out, we'll make sure you get those. You can be seated until we get all that straight.
Okay, thank you.
My understanding is the jury has reached a verdict, is that
Yes,
correct?
Your Honor.
All right, are both the state and defense ready to have the jury come back in and receive the verdict?
Yes, Your Honor.
Yes.
All right, we'll bring them in, but just a second, before we do that, just for the members of the audience that are here in the courtroom, everybody here has been perfect in terms of their decorum, but I just want to remind everybody, please have no outbursts of any, and this is difficult to ask, regardless of which side you're on, but no outbursts of any type of emotional outburst or expression, whether you're for the jury's verdict or against the jury's verdict, and that's for a very important reason. Courtroom decorum requires that we respect a jury's work regardless of what their decision is. And so if you feel as though you can't control your emotions, whichever way they decide, I'd ask you just wait in the hallway, and then you can find out the information of what happens at that point. But if you're going to remain in the courtroom, just please don't show any expression. That way the jury doesn't feel that they're being influenced in any way or criticized in any way, because again, the rules of courtroom decorum require that. All right, so everybody understand that? Very well. We can bring in the jury. All right, please be seated. Ladies and gentlemen of the jury, it's my understanding you all have reached a verdict. Is that correct? All right, if you'll please hand the verdict form to the bailiff. All right, the verdict form is filled out, signed, and dated. I will provide it to the clerk, and she will publish the verdict.
In the Circuit Court of the 20th Judicial Circuit in Fort Lee County, Florida, criminal action. State of Florida versus Christopher Davis. Case number 24 CF 000083. Verdict. We, the jury, finds as follows as to count 1 of the charge. Count 1, second-degree murder. The defendant is guilty of second-degree murder. Count 2, tampering with physical evidence. The defendant is guilty of tampering with physical evidence. Count 3, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, target. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Count 4, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Publix. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Count 5, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, PNC Bank. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Count 6, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Starbucks. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Count 7, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Walmart. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Count 8, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Seacoast Bank. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Count 9, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, Home Depot. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Count 10, fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. Anne Therese Aesthetic Medicine. The defendant is guilty of fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. So say we all, dated June 26, 2025, foreperson.
Have the report back, please. Does either side wish to have the jury polled?
Please.
All right.
Mr. Crosley, is this your verdict and the verdict of the jury as a whole?
Yes.
Mr. St. Clair, is this your verdict and the verdict of the jury as a whole?
Yes.
Ms. Najjar, is this your verdict and the verdict of the jury as a whole?
Yes.
Ms. Hunt, is this your verdict and the verdict of the jury as a whole?
Yes.
Ms. Karen, is this your verdict and the verdict of the jury as a whole?
Yes.
Ms. Ortego, is this your verdict and the verdict of the jury as a whole?
Yes.
Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. With that, ladies and gentlemen, again, we thank you for your service. You may get whatever belongings you have here. Make sure that you get them out of the jury room, and the bailiff will escort you out. Thank you.
All right.
All right, let the record reflect the jury has exited the courtroom. You may be seated. Mr. Davis, the jury has found you guilty of second-degree murder in count 1, tampering with physical evidence in count 2, count 3 through 10, for fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual. They found you guilty on each of those counts. So I will adjudicate you on all counts that the jury found you guilty of on the verdict form, including second-degree murder and tampering with evidence, and the fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individual, again, in counts 3 through 10. What says the state regarding sentencing?
Judge, if the court would like to go ahead and sentence Mr. Davis today, he is not entitled to a pre-sentence investigation report.
Okay.
Mr. Davis has been repeatedly convicted of multiple felonies. As such, he would not be entitled to a pre-sentence investigation report.
All
I
right.
do believe that we have members of the family and friends that are present that would like to address the court.
For victim impact?
Victim impact. Otherwise, if defense counsel is seeking an additional date, we understand that as well. So.
Okay. All right. And from the defense, then, is there any reason why the court cannot pronounce sentence today?
Judge, I would ask if we could set it out. I was inquiring about if you, one of your family members to be present, which we don't know at this time, but that's the reason I would request to put it out a month or so.
But do you agree that he's not entitled to a PSI? Pre-sentence investigation
prior
report?
convictions. I mean, he was brought from a prison here from another state.
Okay. And I don't know what his prior record is, but other than that, do you anticipate there was no one, was there anybody here today or throughout the trial on his behalf that is here today to be here? Or?
Okay. I guess we could proceed.
All right. The state want to proceed then? Do you want to start with victim impact, or would you rather make a recommendation at this point, or how would you like to proceed?
Judge, if the state may have a brief moment to speak with the victim's family members with
Okay.
regards to, so that way we can narrow down who would like to present, who would
That's
like
fine.
to argue to the court.
I'll give you a few minutes.
Thank you, Your Honor.
All
Appreciate
right.
that. Same score sheet as well.
All right.
With that, Judge, if I may, the state would like to present victim impact at this point in time.
You may.
And follow that up with a brief argument.
All right.
At this time, Judge, the state would call Miss Verna Bernstein.
Just raise your right hand. Do you swear or affirm testimony you give will be the truth, the whole truth, nothing but the truth?
I do.
You can take the stand.
Go up here.
Yeah. All right. You may proceed whenever you're ready.
Thank you, Your Honor. Good afternoon, ma'am.
Good afternoon.
Could you please introduce yourself to the court by telling him your name?
My name is Verna Bernstein.
And did you know a gentleman by the name of Barry Schmalbach?
I did.
And how did you know him?
He was my nephew, my stepnephew. My sister is Vivian Schmalbach, and my niece is Emily Schmalbach Scaletta.
Okay. And is there anything that you'd like to bring to the court's attention that you believe is pertinent with regards to sentencing in this particular case?
Yeah. You know, Barry was a big, beautiful light in my family's eyes and their life. You know, he was there with Emily when she was growing up. They became really good friends. And even later in life, he came back to the family. And he's just always been a very kind and generous person, almost to a fault. But Emily was getting so much closer to him again, and she had just lost her dad. She lost her grandmother, who she was close to, and now this. And it's heartbreaking to see someone you love go through this much loss. And it's just unbelievable. You never think it's going to happen in your family. But in this case, it did. And, you know, to not be able to grieve for him properly, I just think it's so unfair. He did not deserve to go this way. He just gotten healthy. He was trying to live his life, and he was just taken like that. And he should have been on this earth. He would have meant so much more to more people. He was kind. He was respectful. He took responsibility for, you know, his mistakes in his life. And, you know, it's a tough loss for our family and for his friends. He had a lot of very close friends. So I'm here speaking for my sister and my niece.
Thank you, ma'am.
And he's also going to miss the birth of his first niece. Maybe not his first niece, but. Thank you.
Judge, the state would like to call Ms. Sherry Steyer.
Do you swear or affirm testimony you give will be the truth, the whole truth, nothing but the truth?
I do.
You can take the stand. You can do that.
Thank you. Hi.
Good afternoon, ma'am.
Hi,
Would you please introduce yourself to the court by telling him your name?
my name is Sherry Steyer.
And Ms. Steyer, do you know a gentleman by the name of Barry Schmalbach?
Yes,
And how did you know him?
he was my baby brother.
And is there anything specifically that you'd like the court to take into consideration as it relates to sentencing this particular case, as it relates to your brother?
We weren't very close at the end, but I've always loved him. I always knew he was a good person. I'm sad that we're never going to be able to reunite on this earth. I look forward to seeing him. We are good. We are at peace. together. I know this in my heart. I am sad that Barry was just starting to get his business going when this happened. And I miss him. I've always missed him, but I really miss him now. And I hope this is okay to say, but he does come to me in my dreams. That's how I know that he's okay and he's at peace. Okay.
Thank you, ma'am.
Thank you. Thank you.
Lastly, Judge, the state would like to call Ms. Rosalie Falco.
All right. If you'll just raise your right hand, do you swear affirm testimony you give will be the truth, whole truth, nothing but the truth?
Yes, sir.
You can take the stand.
Thank you. Good afternoon, ma'am.
Hi, good afternoon.
Would you please introduce yourself to the court by telling him your name?
My name is Rosalie Falco. I am Barry Schmalbach's friend for 40 years.
And you're one of the same Rosalie Falco that testified in this case.
Yes, please.
Is there anything
Sorry.
that you'd like the court to consider as it relates to sentencing this matter?
Yes, please.
Please.
Okay, so Barry Schmalbach was not just a friend. He was a family to all of us, and we all showed up for him. He may have looked like he lived in Florida alone, but he had a whole tribe that was always by his side. Barry was a ride or die. He stayed with his people. He was loyal. He was admirable. He was a person who brought everybody together. He had friendships all over the world that lasted lifetimes. If you met him for 5 minutes, you loved him because he was genuine and very, very, very truthful and very true. He was the best person you'd ever meet. Barry's sister can't travel because she's having her first baby. And Emily wanted you to know that she just got her brother back. And Chris took that away from her. He took away the niece that he would have loved to have seen and bounced and held on to. She misses him dearly and she loves him. She's happy the justice was served, but you know, she's a baby. She's only 30. So she missed out what could have been her older years to really enjoy her family as an adult, which got taken away from her. And she's an only child. So she truly doesn't have any other siblings now. That was her family. She's blessed in many ways, but her brother is gone. And that's something that we cannot ever replace. And Barry left a mark on everybody. I think he left a mark here as well this week. People that knew him for a year or two, people that knew him for lifetimes. You know, Margaret was like a daughter to him. And I heard many stories of the love, the deep love he had for Margaret and Leon. Leon's his family. Leon is his brother. The love that is in this room for him can't be matched. Can't be matched. And we would show up 110 times if we had to for him. So I just wanted you to know that he was an amazing person. That's all.
Thank you, ma'am. I have nothing further to present at this time, just mere argument.
All right. Anything from the defense this time?
Argument, Judge.
Okay.
We proceed. We'd ask the court if you do see a score sheet, you'll notice most of the priors are all property crimes from Georgia and South Carolina. And there's no crimes of violence in his past history. The score sheet guidelines recommend a lowest permissible of 286.05. you'd be requesting that sentence from the court. Thank you.
All right, state.
Judge, this court, over the past 3 or 4 days, has received information, and it's gone through 40-some-odd witnesses. It's gotten 57-plus pieces of evidence before it. It's heard all the arguments. I'm not going to go ahead and be repetitive. I'm going to be brief and tell this court that the only sentence that Mr. Davis deserves in this particular case is nothing short of life. Respectfully requesting Mr. Davis to be sentenced to life. We're respectfully requesting Mr. Davis to be sentenced to the 15 years for the tampering of evidence in this particular case. We're also asking that this court sentence Mr. Davis to 5 years on each count of the fraudulent use of personal identification information by a deceased individual. And we're asking that all of those particular counts run consecutively. And that's for the cost of prosecution, Judge. We're respectfully requesting the court to order and reserve.
Okay. Any other of the financial, any statutorily mandated fines, fees, or costs, and are there any minimum mandatories in any of the counts?
There are not, Judge.
Okay.
We're just seeking a PD fee and cost total $400. Any objection to that? $400.
$400
The
defense counsel fee?
Defendant said he had no objection
Okay.
to that fee, Your Honor.
Mr. Davis, is there anything you would like to say to the court prior to the court pronouncing sentencing? Okay. And is it true you have no objection to the defense counsel's request for $400 in defense counsel fees? That is true or not true? It is true. Okay. All right. So let me take care of the financials. Are there any statutorily mandated ones? Okay. So under count 1, which is second-degree murder, I previously stated that the jury had found you guilty. I adjudicate you guilty on that count. You will be required to pay the $400 in defense counsel fees. I'll order in reserve on cost of prosecution. There is a minimum statutory amount of $100 that I will order that, and I'll order in reserve on anything above that. There is $413 in court costs and no other application fees or anything. Or is there, well, there would be an application fee.
There's one.
$50 public defender application fee. $2 for law enforcement fee for Cape Coral. So that's $415 in court costs then. You will be ordered to have no contact with the victim's family, and
Excuse me, Your Honor. If I may interject, I apologize. I may have misspoken as related to the tampering charge. It's a third-degree felony. It's punishable by up to 5 years in the Department of Corrections. So say we would be asking that that be 5 years and obviously consecutive as well. So.
Each of those you wanted consecutive?
Yes, Judge. Thank you.
All right. All right, then. So on the tampering with physical evidence and each count of the fraudulent use of or possession with intent to fraudulently use personal identification information concerning a deceased individuals. That's counts 3 through 10. Each of those is a third-degree felony. And again, you've been adjudicated guilty under those counts, and I will sentence you to 5 years in the Florida Department of Corrections on each count, consecutive with each other, and consecutive to the sentence that I will pronounce in count 1. That means they run one after the other. They don't run at the same time. Then, in each of those counts, counts 3 through 10, I will order restitution reserve on any amount in there. And again, in count 1, I will order restitution reserve on any amount if if that comes about. As for count 1, second-degree murder, I've reviewed the court file. I have taken judicial notice of the court file. I have presided over the trial and listened to the testimony and evidence presented. I have reviewed your criminal punishment code score sheet. It does appear you have numerous felony convictions. Looks like mostly out of South Carolina and Georgia. The lowest permissible sentence on this criminal punishment code score sheet is 286.05 months. The maximum sentence under this offense would be life in the Florida Department of Corrections, a life sentence. It is the considered judgment of this court that as to count 1, second-degree murder, which I had previously adjudicated you guilty, you will be sentenced to life in the Florida Department of Corrections. That sentence will be imposed, and all the other counts, the sentences and the other counts, will run consecutive to that, including count 2, which is tampering with physical evidence, a third-degree felony, and on that one you're adjudicated guilty and sentenced to 5 years in the Florida Department of Corrections. That sentence will run consecutive to count 1, and then counts 3 through 10, each of those will run consecutive to each other, meaning one after the other. But as to count 1, you will receive the sentence of life in the Florida Department of Corrections. And what credit does he have?
365 days.
You get credit on each of the counts for that. Again, there'll be no contact with the victim's family and any other terms or conditions.
There you are. Thank you.
All right. Sir, that'll be your sentence. You have 30 days to file an appeal. An appeal would have to be filed with the Lee County Clerk's office here in this building. You've been appointed an attorney for this trial. If you can't afford an attorney for the appeal, the court will appoint one for you. But just remember, you've got 30 days from today to file an appeal. That will be your sentence, and you'll just get fingerprinted and remanded. Go ahead.
Judge, I think you also need to order a DNA sample as well, Judge.
I'm sorry, what?
A DNA sample?
Oh, I'm sorry, yes, you also be required to submit a DNA sample for the FDLA DNA database. Thank you.
Thank you.
And that'll be each of the counts. So here's the verdict form. Okay. All right, we recess. Thank you. We'll be adjourned.